in the courthouse where time stood still. Generations pass on the hill, prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight, came in to visit her at night. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption's grip tight as a vice. In this endless trial, we pay the price.
Hey, folks, and welcome to day 141. And no jury today. It is motions here. I need to comb my beard more often. It's getting wild. Yeah. So it's motions hearings and motions in limine and motions of this and that and motions up and motions down and oh yeah. No curse and any bets over under that love has done nothing at all during break. Oh, she has. Oh, she has. Good morning. Oh, she has been busy. Well, she wrote probably one of the most idiotic motions of all times. Of all times, folks. Of all times. And while we are waiting for court to start, let's read it. Let's put that on the banner. Yeah. There. Let's put that up there. Yeah. Motion in limine to allow the state to present all relevant evidence to the jury and deny defendants' objections to the presentation of relevant evidence on the basis that said evidence is a waste of time. First of all, motion in limine is literally we like to exclude something. And as last time I read one of these is I told you she can't write a motion if her life depended on it. She really can't. Now, what this means is that she wants to do as she did during Glanville. Just on and on and on and on and make the judge refuse 403 objections. The state of Georgia, by and through Fannie Willis, district attorney, blah, 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 hereby moves this honorable to allow the state to present all relevant evidence to the jury and deny objections to the presentation of relevant evidence on the basis that said evidence is a waste of time. Respectfully submitted this 8th day of October 2024, signed Adrian Love. Certificate of that's it, folks. That's all of it. There's no case law. There's no rule of evidence. There's nothing in it. It's Miss Love whining about the judge sustaining objections of 403. No case law, nothing. This is it. This isn't even a first-year law student level. There's nothing to it, folks. There's nothing to it. Now, luckily, Doug Weinstein, you glorious human being, replied to this. State of Georgia versus Kendrick. Opposition to state's motion in limine to allow the state to present all relevant evidence to the jury and to deny defendant objections to the presentation of relevant evidence on the basis that said evidence is a waste of time. This is shade. This is shade from. This is underhanded shade from Mr. Weinstein. Oh, you glorious human being. And there's a footnote. Wow, that's really a mouthful. The footnote. Oh, you glorious human being. You glorious, glorious human being. All right. The defendant, Kendrick, via through his undersigned counsel, without waiving any other rights to which he is entitled, filed this opposition to the state's motion, stating the following. In a surprisingly succinct and efficient bit of lawyering from the state requests that this honorable court deny all future defense 403 objections regarding the state presenting relevant evidence that is a waste of time. The state cites neither statute, case law, nor the highest law of the land according to the state, Carlson on evidence, to support its position that the court take up the challenge of overriding the edicts of the Georgia legislature, along with virtually every other legislative and judicial body in our nation, by ignoring OCGA 244403. While the state's motion genuinely merits no response, the filing of its frivolous motion may indicate that the state plans some form of carpet bombing of additional, pointless, cumulative evidence clearly excludable under Rule 403, and is laying down some type of suppression fire through this motion. Therefore, undersigned counsel feels compelled to object. Ironically, the state's motion is a perfect example of the need for this honorable court to weigh in on the state wasting the time of all involved in the present case by barring otherwise relevant evidence that is a waste of time under Rule 403. In a sense, the motion needs no opposition as the motion itself serves as its own evident opposition. Wherefore, Mr. Kendrick respectfully requests that this honorable court deny the state's motion to bar ever ruling for evidence for the defense in future Rule 403 objections. 8th day of October. By Douglas S. Weinstein. I have to say, that's the headline. Oh, wow, that is really a mouthful. Oh, the shade. Oh, Doug Weinstein, you glorious human being. Yeah, Samantha, you imagine trying to control how the defense objects in a trial. She has officially lost her mind. Oh, she lost that a long time ago. Oh. 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 I mean, this motion from Miss Love is. I thought the last one was bad, but that was just bad. In the last one I read a few weeks ago was bad, but that was just word salad, probably written. But as Ian Ronco pointed out to me, AI writing often has a better tone to it. So that her word salad in that motion was just bad. And here she is, not even if a first-year law student presented this to me, they would fail. I would be asking, did you not pay attention at all in class? I cannot express to you guys how bad this is. It's really, really that bad. It's oh God. Yeah. Oh yeah, this as well. Forgot about this one. She also filed this piece of garbage. And again, I'm not entirely sure. Motion in limine to revisit evidentiary ruling. That's not a motion in limine. That's a motion to revisit evidentiary ruling. It's not a motion in limine. This is so bad. The state of Georgia, by and through Fannie T. Willis, District Attorney for Atlanta, hereby moves this honorable court to revisit the court's ruling excluding States Exhibit 528Y, attached hereto as Exhibit A, on the basis that the exhibit contained inadmissible hearsay. Respectfully submitted October 8th, which was yesterday. Now, what was this? Piece of evidence. Do you remember this? This is the piece of evidence where she wanted to. Yeah, I'm not entirely sure. I mean, there was something about the comments that she represented to this to the. Yeah, no basis for revisit. None whatsoever. She wants to revisit the sustained objection of hearsay because she misrepresented to the court what she was going to ask that witness about this particular photo, if I remember correctly. Yeah, daily quip. No basis. No basis whatsoever. She just said more or less, please do it. Now, I do believe there is some form of tactics behind this piece of garbage. One of it may be that she is going for disqualification of the judge. That she is starting to lay a foundation of garbage to then ask the judge to recuse herself because she denied so many motions and doesn't allow her to present relevant evidence and such. Now, I have high doubts that will be successful. I mean, she will ask that they recuse another judge from this trial. No, I didn't see a phone number on it too, so it might be some other garbage about this. Let's take a closer look on man, use some shit. Notes, do opt-in, Stunner Bumpkin, Atlanta, Stunner Bumpkin. No, 3145. I think she whited out the rest of the phone number here. So yeah, it is the one with the phone number. If you check over here. Hold on while I... Yeah. This looks whited out, the entire phone number. So she still wants the phone number in. And remember, she told the court during sidebar that she wasn't going to ask about... She wasn't going to ask about the comments. But then she tried to argue to the judge, well, it's a number, it's not a comment, which was so stupid. Now, they have started in court. They have started in court. All right. Subtitles. Sound. I need the correct banner up. No, not that one. Not that one. That one. All right. Let's go. Let's see what today brings.
Betty can be seated. All right, we have a lot of issues to get through on our non-jury days for the next few days. Take the easy ones first. The state's motion in limine about overruling whatever objection the defense might ever offer to evidence on the basis of 403 waste of time and the defense response in opposition thereto. I am ruling for the defense on that one for all of the reasons stated in Mr. Weinstein's response in opposition. Takes care of that one.
Folks, the shade in this from Judge Weinstein, there's nothing to it. She didn't even address the writing. She just I rule in favor of the defense. She didn't say she denied the state's motion. She ruled in favor of the defense. That is a step higher.
Motion in limine by the state to revisit the court's ruling excluding State's Exhibit 528Y. I have considered that, and I will not be changing my ruling on that.
Okay, that's
the couple of
the two motions Ms. Love wrote during the break, denied, thrown out. She didn't even bother to address it with arguments. It's just denied.
Uncharged post-indictment intrinsic acts that were still outstanding. I've got one question on the circumstance that involved Mr. Ryan and the fight and I can't remember which co-defendant, but there was a co-defendant who entered a guilty plea and attested to a conversation having been had about protecting a YSL member in the jail and hurting somebody else. What was that about? Do y'all remember that? And did that have anything to do with this? Or were
No.
those unrelated?
That was before this.
Okay, all right. Okay, so the court has determined that neither the Ryan situation nor the alleged passing of Percocet to defendant Williams in court meet the requirements to be an intrinsic act. And so I am not going to admit either of those. And I've also reconsidered, thought again about my ruling out the Stillwell situation of some contraband being in his cell, and I'm going to stand on my ruling with regard to that as well.
Okay, that was a bunch of intrinsic acts the prosecution wanted in. That's out. So it's a good start with the prosecution losing. We like that. We like that a lot.
One question I saw in my notes, something about the search for Attorney Johnson, the search of Attorney Johnson's laptop, and something that Defendant Williams had requested with regard to that. Can you, Mr. Steele, refresh my memory on what that was about?
Yes, can I have just 1 second?
Sure.
Your Honor.
Yes.
To the court. And good morning, Your
Good
Honor.
morning.
Good morning to everyone. Can I make a statement to the court without the prosecutors here and without the media, so it would be on a sealed record? And then if you believe it should not be sealed, obviously I will repeat it, or you can have Ms. Winfrey read it back. But I believe that in an abundance of caution.
Come on up.
Okay.
Okay, that was interesting. And Miss Love is wearing her yellow jacket again. Hold on, folks. I need to get something. I hope it is easily available. All right, folks. Who wore it better? Huh? Who wears yellow jacket better? I'm going to create a poll here. Okay. Okay, and they are back. Good timing.
All right, so I appreciate that, Mr. Steele, and that can be sealed to the extent this record ever goes anywhere.
Okay. I wonder what that was. Yeah. Oh, and by the way, I have
All right, I know that there are some things outstanding that concern Mr. Ryan, and there's been a request that that be handled tomorrow instead of today. That's fine. So I'll set that aside for now. I appreciate everybody submitting case law on the issue of whether the RICO conspiracy can be established based on an overt act that's not alleged in the indictment. Frankly, it's a lot of stuff to read, and since some of the submissions were late last night, or, basically all throughout the day yesterday, I have not read all of that, so we'll take that up at some other time, and that's really more of an end of trial issue for us anyway.
she punted that
Okay,
forward.
I think we're ready to argue and consider the motion in limine. What was it, 62, I guess? All right.
Okay, now we are into Mr. Steele's motion in limine number 62.
Your Honor, may I approach?
Yes. Thanks.
Your Honor, I just handed this honorable court and the parties, although I ran out of copies, I just gave it to Mr. Matthews. The case I cited in motion limiting number 62, Ebersole, E-B-E-R-S-O-L-E versus State. It's 371 Georgia Appeal, 520. It's in Division 1C as in Colette. It's 901 Southeast 2D, 572, a 2024 case. And Your Honor, what happened in our case previously, and I understand the honorable court was not with us, but the prosecution through ATF agent Racy was testifying. He was at one time with Cobb County Police Department, and he was the lead detective on a case against Mr. Jimmy Winfrey, and that is in Cobb County case number 15-9-2765. And he was asked by Prosecutor Hilton about a jail call. And the jail call had something to the effect of, when Mr. Winfrey comes home, he will be given a Porsche and $250,000. It was something to that effect. And Ms. Hilton then asked Detective Racy, within approximately a month from that time, that jail call that the jurors just heard, did in fact Mr. Winfrey enter a guilty plea? I objected. That guilty plea was vacated and found to be coerced by the Georgia Supreme Court in Winfrey, W-I-N-F-R-E-Y versus State, 304 Georgia, 94 816 Southeast 2D 613 2018. And it says specifically in that case that that guilty plea is void, is null, and cannot be used for any purpose. We approached the predecessor judge, and he said he didn't know about that case. It's all on the record. It was at the bench. And I said, well, here's a site. And he said, well, I'm not going to read it. And I said, well, I'm going to cross him on it, and I'm going to subpoena the lawyers. And I put them on my witness list who entered that plea. And I have a certified copy of the Supreme Court opinion vacating it. And this predecessor judge said I couldn't do any of that. Ms. Hilton then came back to the podium and asked Agent Racy the next series of questions. Well, was that plea, for whatever reason, vacated? And a short time later, did Mr. Winfrey enter a guilty plea? I again objected. I was not allowed to go into it. The essence of this motion, number 62 of Mr. Williams, is I believe that that's already a constitutional violation. So it has to be harmless beyond a reasonable doubt. Because
Was there any kind of instruction
no,
given?
no, it was, I can't cross on it. Mr. Matthews can't cross on it. We were all barred. And it came out that way, that Mr. Winfrey pled guilty. And this dealt with the April 26, 2015 tour bus shooting of a gentleman named Dwayne Carter. He's a phenomenal artist, musical artist, known as.
Yeah. That guilty plea back in 2016 legally doesn't exist, as Daily Quick Bites points out, because it was vacated. And something that doesn't legally exist should not be entered as evidence or testified about in court. That is, in my opinion, an unforced error by Judge Glanville. And this will probably take Judge Whitaker in a bit of a conundrum, because she already said she's not planning on reversing any of Judge Glanville's decisions. I think she has to here. But how do you then rectify it to the jury?
Lil Wayne. So the state gets that in. Now, the predecessor judge did keep out the indictment on my objection, because the indictment names as co-conspirators, unindicted co-conspirators, Mr. Williams in that event, and it was a RICO count. The further objection was that Mr. Winfrey, he didn't really plead guilty. This is the most favorable Alford plea, and I attached it to Mr. Williams number 62 that, that I have seen, where the predecessor judge specifically, excuse me, not the predecessor judge, Judge Staley, it's S-T-A-L-E-Y, and it's Staley Clark, C-L-A-R-K, Cobb County Superior Court. She specifically acknowledges that this is not a guilty plea. This is a best interest plea. He's not entering admission of guilt. The Honorable Steve Sadow, which is Steve, S-T-E-V-E, and Sadow is S-A-D-O-W, was the lawyer. He specifically said that we are doing this just because it's been 5 years and Mr. Winfrey wants to get out of custody. And I attached that, and I have a certified copy of that Alford plea. Anyway, the way it came in was so wrong, and we had cases that we were citing to the predecessor judge explaining that a person who's not testifying, the fact that they pled guilty, people plead guilty for any numerous reasons, should not be allowed to come in against Mr. Williams and the others here. So Going forward, I put this on court's radar because it is my belief and understanding, and if it's not going to happen, that's great, that Mr. Kendrick has pled guilty to being in a criminal street gang, specifically YSL, when he was with Mr. Martinez-Arnold. Martinez-Arnold is going to be a witness, but he did not plead guilty to that charge. And it's my understanding that the state intends to have an exhibit, a certified copy of the guilty plea of Mr. Kendrick. And that should not come in against Mr. Williams or any of the other people here for the same reason.
Let me stop and ask the state, is your position that it comes in against anybody other than Mr. Kendrick?
Here comes the word salad.
I don't believe that a certified copy of Kendrick's conviction would be admissible against another defendant besides Kendrick. And additionally, we intentionally did not tender the certified for Jimmy Winfrey.
For Mr. Winfrey.
Correct.
Yeah.
The
Oh,
court
you
did not
lying
preclude us.
sack
We
of
did not
shit.
tender it.
Right. Okay, so is it the state's position that not the certified copy of the conviction, but the fact of Mr. Kendrick pleading guilty to, it was gang activity and the gang being YSL? What's the state's position on that with regard to that information coming in on anybody else?
I think that his guilty plea, the fact of his guilty plea is admissible against him, and I don't believe that it's admissible in normal cases against anyone else. In this circumstance, I also don't believe that it is. At this time, I don't believe the cases that I've read suggest that it would not be admissible against another defendant. That's
All right. I mean, I think that's generally correct. So I think I've mentioned before needing a limiting instruction. And I know we're not quite at that stage yet, but I don't know when you intend to introduce that. And
not for the next 2 weeks, I believe.
okay, well, can you go ahead and be trying to put together whatever appropriate limiting instruction there would be? And then I would think that the position of both the defense and the state would be the same with regard to Mr. Ryan's murder jury verdict.
Right. Well, yeah, I know that the court, I know we addressed it last week, and I was saying that I was looking into that. So I don't have anything to counter the position that it's only admissible against Ryan. I don't have anything to counter that position yet.
So we'd need a similar limiting instruction for that. Let me ask the defendants with regard to whatever information did come in on Mr. Winfrey having pled, that having been overturned somehow, and then him having pled again. There was no information in front of the jury that it was an Alford or a best interest plea?
That's true.
Okay. We've obviously introduced that concept to this jury at this point. Does the defense want me to instruct sometime at the end of the case that, hey, with regard to what you heard about Mr. Winfrey's plea, that was also a best interest plea, and so the same things apply?
Yes, and I intend to
Okay.
call the, in my case in chief, I updated my witness list, the
Okay.
lawyer at the first one when it was coerced by the court, and that's why it wasn't knowingly, freely, and voluntarily given, and then call Mr. Sadow.
All right, well, I don't know that we're going to be doing all of that, because if it is before the jury that the other one was overruled, then The other one really doesn't need to be taken into consideration.
It was not before the jury. The other one's overruled. And please, we have to look at the transcript.
Okay.
But it was something to the effect of later, for whatever reason, a short while later, did he re-enter his guilty plea?
Okay, well, maybe we will get the necessary information to the jury without having to do it through a couple of witnesses. Maybe y'all could work on a stipulation. Why don't y'all make efforts to work on a stipulation that would cover that?
Also, Your Honor, there was the matter of the playing of Mr. Zachary's 2017 interview by Mr. Williams. Your Honor, if I am
Ms. Love, why are you changing the subject? Oh, she's trying to swipe this under by moving on?
not mistaken, that the portions that were played included a reference by Mr. Zachary to the fact that Mr. Winfrey had entered that guilty plea. If I'm wrong, I accept that, but my memory is that from the time that it was first broached way back when, earlier this year in April or whenever it was, and now Defendant Williams actually introduced the fact of the guilty plea by Mr. Winfrey through cross-examination of one of the state's witnesses.
He was forced to because
In
your
playing
misconduct.
a video, the witness that was being interviewed actually talked about that guilty plea.
Well, that may be, but regardless, we need the correct information in front of the jury. So,
Can I just make a statement on that? Is that okay?
yeah.
So I do believe that Mr. Zachary said that Mr. Winfrey pled guilty.
Uh-huh.
But, you know, to say that I somehow then introduced that concept, you know, I'm dealing with a fact that already came out
Had
before the
already come
jury.
out, right.
So I don't think that
Okay,
holds much weight.
yeah, but I would like for y'all to try to figure out a stipulation that will cover what the situation was, and then I'll give an instruction about that having ultimately been a best interest plea.
Okay.
Okay.
When I say okay, I still intend to call the witnesses, but I will follow your direction.
Okay. Well, I mean, you know, if that's what's necessary, that's what's necessary, but I don't believe it should ultimately be necessary. I think there ought to be a stipulation that could be worked out. And if it's not a stipulation, then you can just propose what the stipulation would be and I'll take it from there maybe.
Okay.
Okay. All right.
Thank you.
Okay. So. So on motion in limine 61, there was one part that was still outstanding, which was the issue of the text messages that are captured through the wiretap. And there's, I guess, a best evidence objection to that. So what's the state's intent on that?
With respect to the text messages in the wiretap are as they were sent through the carrier. So.
Okay, and which carrier? Have we already had all of the various carriers come in and
I think it's
certify?
It's Verizon, and no one has talked about the wiretap evidence yet. That has not been broached yet.
Well, I'm broaching it now
No,
because
I mean,
it's in this motion in limine.
Through a witness in front of the jury. That's what I meant.
Okay, so those records then, we haven't had business representative come in and
Correct.
say anything about those records. But are they going to ultimately?
We have a business record, I think.
Okay.
Just 1 second. What we have on our. We have the witness, the T3 custodian, the wiretap custodian, who will be addressing the content or the wiretap issues in the system and the way that the information is captured.
When you say, just for clarification, Your Honor, when you say the wiretap custodian, who are you referring to?
Who?
Mr. Scherer, S-H-E-R. S-C-H-E-R-E-R.
Okay. And, okay, so he'll testify to how it gets captured, and is he going to be able to certify that it's accurate?
Yeah, I believe he will, just as much
Okay.
as it. Yes, I believe that will be satisfied with that witness. Additionally, when we are, I believe that I understood the question last week to deal with not the text message box per se, but the one up under it, which was the notes, I think. And I don't recall if that was something that I misunderstood, but there's a portion of that wiretap that has sort of an interpretation, the listener's interpretation of what was heard. That's not what we're trying to introduce. It's just the content of the actual text message box.
Okay. So is there anything else I need to entertain with regard to that?
I don't believe so, but I'll let counsel speak for themselves.
Defense counsel?
Miss Love is surprisingly submissive this morning. Surprisingly submissive.
So, Your Honor, I spoke with the Honorable Mr. Atkins, and he was going to verify, but my belief, and I need verification, is that if I was being wiretapped and I'm sending the Honorable Carlton Matthews a text message, "I'll meet you tomorrow at the Braves game," it is not collected the way I sent it. So it's somebody, the sworn person who is on the team who's allowed to be a listener or a reader of the contents of the wiretap would then read that, and they put in the line sheet, Brian Steele's text was to Carlton Matthews, "I'll meet you at the Brave game tomorrow." If that's the way it is, I'm objecting, because then it's not the original. And then I want to know what you just said, if they can lay a foundation that they have the original text message, or Verizon, it was over my objection last time, but they kept it accurately in the course of business. I'll waive this objection, but I do need Ms.
Okay.
Atkins, who's been nothing but great always. He said that, unless he found it out now, he said that he would make sure which way it is. If it's
Okay.
an actual replica or if it's a human being.
Sure.
And that's
Yeah,
my
that would
issue.
definitely be kind of
And
a
we-
different circumstance.
And we verified, Your Honor. So with the T3 system, Your Honor, the text message, there's two boxes. There's a text message box and a synopsis box. In the text message box, that is the text message that came in through the phone. Our understanding is, while you're in the wire room, you can either accept or not accept it. So you can either accept it as it comes in or not accept it and it won't show up. But
Okay.
Miss Hilton, with all due respect, are you qualified to assert that? Or are you just saying something?
person viewing the wiretap cannot manipulate the text message box. The other box is their own note.
That's the notes
That's the
box.
notes, and we're going to try to show you an example. We were trying to find an example with both, but we can share the
Okay.
screen.
Well, y'all don't, do I understand you to be saying that the state does not intend to even try to introduce anything from the notes synopsis section boxes?
Correct.
But only from the text message boxes, which are supposed to be a verbatim capture of the text?
Yes, Your Honor.
Okay.
That foundation laid, yes.
Okay.
Now, I'm no expert in this at all, but if they have the text message, why do they have to have it through the wiretap section and the wiretap person when you can extract it through Verizon? Yeah. Oh, Gigi, great point. The person doing the wiretap chooses which text messages to accept or not. That's so they can actually say this has nothing to do with it, this has nothing to do with it. That's very subjective. That's not objective. We would need all the texts, not just the ones that that person put in there. If that person, the wiretap person, is the one that chooses.
All right. Thank you.
Thank you.
All right, there was a kind of overlapping with regard to Summer Good, a motion in limine 63, and then a Stillwell motion that covered some of the same potential evidence. Are we ready to go through that? I know it sounds like there's agreement as to some things and some things need to be litigated.
Your Honor, I don't know if it needs to be litigated today. I think that it is, once Ms. Good takes the stand, if we lay the proper foundation, there'll either be a foundational objection or not, but we agree generally with both motions that anything that is speculation, anything that is hearsay, we do not intend to get in with Ms. Good.
Okay.
However, if there is, I think there might be disagreement on her knowledge of Mr. Williams, the state would intend to lay a foundation before we get into that question.
Okay.
But I don't think it's anything we can litigate until she
Okay.
takes the stand.
All right. And so this kind of summary sheet that's discussion on motion in limine 63, motion in limine re Summer Good, that's pretty much what we might be litigating or what foundational issues there might be.
Yes, Your Honor.
Okay. All right, so we'll just come back to that. All right, and then we have a basically supplement, a motion and supplemental motion, joint motion to exclude evidence that y'all have also run down what you agree to and what you don't agree to. The things that there is no agreement on right now, is that something we can litigate today?
Yes, Your Honor.
All right. Okay, let's turn to that then. And would it be helpful to access the Dropbox for that?
Yes, Your Honor.
Okay. Link was sent October 8th at 11:36 by Mr. Adkins. Or y'all may have it before then as well.
And Your Honor, just to be clear, when, for example, if that motion, paragraph 3 in that Dropbox link, they follow the same numbering. So the
Okay.
court, counsel should all be able to easily find what we're addressing because the
Okay.
numbering is identical to Mr. Steele's motion.
All right. Well, I don't know where it is. I know I got it, but.
Okay. Microphones are off. Skip ahead a bit.
All right, I guess we will, if everybody's got the link up, we can just start at the beginning with item number 1. All right, and what's the relevance purpose of image 623?
Thank you, Your Honor. Your Honor, this image 623 is a gun that was found underneath a mattress when one of the co-conspirators, Antonio Sumlin, was arrested in the May or April of 2022, Your Honor. And we believe that this picture is relevant to show that this, one of the YSL co-conspirators, the nature of this enterprise. One of the things that we allege in our preamble to the indictment is that YSL maintains armed individuals ready and willing to preserve, protect, and enhance the reputation, power, and territory of the enterprise. And the fact that he had this gun in the bedroom that he was in underneath his bed, we believe is relevant to show that.
All right. And who's going to be arguing these for the defense? Sure, I mean, that's fine. All right, whomever is going to take this portion.
All the prosecutors sounds surprisingly submissive today.
Your Honor, it was explained in our case law that our gang statute was modeled after our RICO statute. And I cite the case to the court, and I did not bring extra copies. I apologize. Alexander, Alexander versus State. It's 371 Georgia Appeal, 532. It's in Division 2, 901 Southeast 2D, 584, 2024 case. And what our second highest court explains is that it is essential that the state, I'm quoting, demonstrate that the commission of the predicate act was intended to further the interests of the gang. So this is a gang count, and the appellate court held that just doing some crime or having some gang paraphernalia, or in this case a gun under the bed, that's not enough to say that this furthers the interests of the gang. There's no nexus. And here, the state has continually put into evidence people associating with other people. This is Mr. Sumlin, correct? Who I believe is going to testify.
Okay.
And the fact that he has drugs or guns or slogans of violence. I'm not saying he does, but you have to show that somehow that gun or that act somehow affected and there was a nexus to the trial that's going on. The state has other pictures of him with guns. So I also say it's cumulative and unnecessary evidence. But that's my
Okay.
argument.
All right.
Can we get a site again? Can we get that?
The site to Alexander.
Yeah, 371, Bush S 532.
Thank you.
And Your Honor, we don't have any other pictures of Mr. Sumlin with guns that we intend. Sorry, if you can hear me, I'm sorry. We don't have any other, and I'm just confirming, but I don't believe we have any other pictures of Mr. Sumlin with guns. This is the only picture we have, and that's because he was arrested with this. Again, the weapon was underneath his mattress when he was arrested.
That is a really interesting case law. Yeah, regarding gang activity, that holding a gun, having a gun, having drug paraphernalia is not enough to show the nexus between having it and doing it in furtherance of the gang. That's an interesting case law.
All right. Well, I mean, it's ultimately a jury determination whether they believe that he had this gun to further gang purposes. But I think in terms of what needs to be shown for the state to secure its admission, that's been satisfied. So to the extent you do not have pictures of him with guns already, then I would admit it. But if you do, then I'm going to exclude it as cumulative.
Oh,
Okay.
cumulative. Here we go. Oh, I hope this is the first in a series of cumulative rulings. For the judge to simply tell the prosecution, speed up. Because you're not going to like what I'm going to do next. If you don't speed up. And to,
All right.
and to my surprise, neither Miss Love or Miss Hilton stands up and starts yapping against her. What happened during this break? What made the prosecution this submissive? Remember, I showed you yesterday on Miss Bennett's testimony the absolute audacity from the prosecution to argue every ruling to the end of the earth. And now they just sit down and accept the rulings. What's going on here?
Right, and then subfolder 3, I guess.
Yes, Your Honor.
All right, and these are pictures of his various tattoos.
Yes, Your Honor, and we actually narrowed down the pictures. So the numbers that are listed, Your Honor, in our synopsis, those 10 pictures
Okay.
show specific tattoos on his person, which are different tattoos that we believe are relevant. So one tattoo has YSL, another tattoo has Salon Life with a snake. Another tattoo has the 5-point star. Another has a tattoo of a die or two
A what?
dice
Okay.
with 5, but up the black dots. And let's see. So
So that's 5. What are the other 5?
other tattoos. So one has the number 5 with A fire, again, we believe that 5 signifies blood, that that he's a member of the Bloods.
Okay, so why don't you pick one of the 5 tattoos and whichever one of those. So dice, fire, plain 5, y'all pick one.
But they're all different symbols.
I
of
know,
different-
I understand.
Okay, so you want for the representation.
Miss Hilton, I have dice. I I also have a snake with the dice. Does that mean I am an unindicted co-conspirator? No, it's a damn tattoo. That's a. No, I'm not YSL. Dice and for freak's sake.
5, you want to pick one thing that represents 5.
Correct. Yes.
Okay. The other ones have Macon and Cleveland, which is him talking about Cleveland Avenue, or Cleveland Avenue being Cleveland. So that's not included in the 5 that you're.
That's a, tell me what tattoo that is. Which image is that? So how about the overall one? Do you need that if you're going to be zooming in on?
The overall, so you can see that it's him in the picture. So that's why we had the overall one.
Okay.
And that picture is taken further away, so you can't.
Okay, well then, do you need the next one then?
So the next one after 641 is 642 where you can, and let me make sure, because yes, it's 642 where you can see the YSL more prominent.
Mm-hmm.
Then we move to 643, which he has Haiti baby, so you can see that more prominent.
Mm-hmm.
Then we skip to 648, which is 2 5-point stars in the lower part of his stomach. Then 649 is the 5 with the fire. 652 is the beast, which we believe symbolizes blood as well. The B is underneath the beehive
Mm-hmm.
on top of the paw. 654 are additional 5-point stars, 5-point stars. 655, it says Macon and Cleveland. 659 is the one with the dice. 665 is slime life with the snake. And then that's all the pictures. And originally there were 24 photos, so we narrowed it down from the 24 to the 10.
So it seems to me that if you have in number 1 to show it's him, and then number 2, you can see a whole lot of the Haiti baby and the YSL and all kind of other things just by zooming in on that one.
But in that, Your Honor, when the jurors have, they won't be able to zoom in on it. They'll be able to see what's in front of them once it's admitted. Yes, we can zoom in on the camera.
So you're gonna, all right. And who's gonna testify to this?
He's coming,
He's gonna be like, yeah, these are my tattoos and here's what they mean.
I don't know.
Or just, yeah, these are my tattoos.
We have tattoos and we have, he'll give his version, but we also have a gang expert who are familiar with these tattoos as well.
Hmm. Okay, well. Just pick one rendition of the fives and use that. You don't need all three of them. All right. Going on to the next folder, there's a 911 call? Okay, what's that?
So, Your Honor, there's a single 911 call and a CAD report. There was a shooting the night before at Waters Road, and the caller notices that her vehicle window is shot out the day that she's making this call.
Mm-hmm.
And so it's a brief 911 call where she's calling to let them know that her car window has been shot out. She doesn't know who shot her car window out, but she's calling the police when she walks outside and notices her vehicle in her driveway with the window shot out from a bullet.
Mm-hmm.
And so the objection was confrontation clause and hearsay because it's not an ongoing emergency. The state's position is it's not a confrontation clause issue because she is not making this phone call for purposes of future prosecution. She doesn't even know who did it or give her thoughts of who might have done it. And in terms of hearsay, although the shooting itself happens prior to her walking out and seeing her window, the state feels that on there's two reasons of a hearsay exception. One being a present sense impression in terms of she walks outside, notices her car window is shattered from a bullet, and she calls 911. And two, in her mind, even though her demeanor on the call, which is not dispositive of if it's an excited utterance or not, but seeing your car window shot out is to me something that would reasonably generate some level of excitement in a reasonable person. And so she's very calm on the call in terms of her voice, but the state feels that either a present sense impression and or an excited utterance for calling the police satisfies the hearsay exception. And that's the state's position in terms of the 911 audio, Your Honor.
Okay, and then is the Waters Road shooting, there's other evidence of that, right?
Yes, Your Honor.
So, Your Honor, there's multiple shootings at that address.
Okay, the Waters Road shooting from March 12th, 2022.
Yes, Your Honor. And so this 911 call and her CAD report, when she calls to report her window being shot, is the court asking if we're going to call the responding officer who went to examine her car or?
No, I mean, the evidence is in or is going to be in that there was a shooting at Waters Road on March 12th, 2023. I guess I'm wondering because of the length of this trial already and it's apparent, I mean, we're going to have to talk about how much longer y'all think this is going to take. But what does it add, I guess, that somebody else?
Yes, please. I really need to know how much longer this will take for the state to be done. Because as you know, folks, I plan to be there in court during closing arguments. I would really like to know a reference of time. Because I do believe that the defense should be done with their case in chief maybe in 30 to 45 trial days, with actual trial days. Maybe even less. And then you have the prosecution's rebuttal. And then, because I really want to be, are you going to wear the yellow jacket when I'm there? That it depends. If I get the information that Miss Love is wearing it, I might have a backpack with several different jackets. And when I see what she wears, I'm going to put that on. No, I don't think I will be allowed to wear this. All right.
Else's window got shot out.
So Your Honor, this is all intimately wrapped into the Shamel Drinks murder, where Mr. Ford and Mr. McMiller are murdered by who YSL believes is YFN members, if gang members, the same group in 2022 that's tethered to Donovan Thomas's group in 2015 and the murder we're on currently. And what the wiretaps we played earlier, where there was conversation, and by earlier I mean a couple weeks ago, where there was guns in the attic,
Yeah.
when they're all hiding and they're running outside, and we played that is Waters Road. So there's a
Right.
number of shootings that we believe was from YFN at YSL. And so this 911 call is a innocent victim of that, in terms of not the intended target whose window is shot out, and calls
Okay.
police, and her, I believe, either boyfriend or husband, Mr. Whetstone, is going to be a witness we will be calling. So the state wanted to, this chronological or timeline is important. It's a brief 911 call, and there's obviously an accompanying CAD report. So the state feels that it's relevant for the jury, because they need to understand the sequence of events in terms of the back and forth shooting and what transpires.
Okay, but do they need to know that somebody who had their car parked on the street or wherever it was parked, a stray bullet hit them?
It's right.
It hit their car, not them, their car?
So, Your Honor, in terms of the relevancy and the low legal standard of it,
I know, I'm not saying it's not relevant. Do you need it?
the state believes we do, and it's,
Okay, y'all are gonna have to start picking some stuff that you just, I mean, this case can't go on forever. It feels like it's going on forever, but there's gotta be something that y'all can say, you know what? I think we ought to be able to prove our case without that. And this,
I completely agree with the judge here, because we know there was a shooting. We know somebody did something. Do you really need all the pictures? Do you really need all the things to show there was a shooting? Do you really need all of it? If it was just that case, yes. But to show there was a shooting, then you need to show, okay, look at these rounds, look at these shell casings, look, or something of the sort, or the cop testifying about, here's my police report. Then, because the important thing here is what's the nexus between that shooting and these defendants. In this trial, that's the important thing for the prosecution. But they don't have that. That's why they're showing all these useless things, because they don't have the actual nexus, in my opinion.
kind of seems like one of those things. And I know that there's not, there may or may not, well, I think there's just kind of a standing cumulative waste of time objection by the defense. But I, as the court, trying to the extent possible, manage this litigation, am raising that sua sponte to the extent that there's not a defense objection. Is this something that, I mean, even whomever, the boyfriend or the husband coming in to testify to it, I mean, if you are establishing the Waters Road shooting anyway, which you are.
yes, Your Honor.
It just doesn't seem like this is really necessary.
Your Honor, I understand I'm struggling for a response, because in terms of it's difficult for me to say what is necessary versus, what is relevant and admissible in terms of, and useful for the jury in making their decision. What is necessary in a case is a hard question to answer.
I know.
And so the state Ms. Latner's is testifying when this comes up, Ms. Latners will be addressing a number of 911 calls and CAD reports that all tether and are connected with this timeline of events. And so the state felt that in terms of brevity or this short 911 call and CAD report anchors a timeline for the jury and is helpful. The state's not intending on calling the officer who responded to check her
that's
window.
good. Okay.
And so the
I think the reason they sent him up there is that he so far hasn't pissed off the judge. So that is why he is arguing this particular thing. But I agree with the judge that if you have the 911 calls, you already established there was a shooting. You have one officer. Here's my report on that shooting. Now we know there's a shooting. What's the nexus between that shooting and these defendants? If you're wondering why I'm going in and out, yeah, my phone is blowing up on me and work, but I'm trying to handle it without disrupting this as much as I can.
state felt that this was I believe Ms. Latners could testify about these two items in probably under 5 minutes.
She probably can, but 5 minutes here and 5 minutes there and 10 minutes the other place. If she's already going to be testifying to 911 calls that came in closer to time, is she going to be doing that?
She's going to be handling a number of 911 calls and CADs, Your Honor, that tether both the Shamel Drinks murder, the murder of Mr. Ford and Mr. McMiller, and the multiple shootings at Waters Road, one of which this is a 911 call in response.
So is there going to be other evidence that either has come in or will come in that this shooting at Waters Road occurred on March 12th of 2022?
One brief moment, Your Honor.
Okay.
Yeah. The objection from the defense was confrontation clause, and the judge went immediately into a waste of time. That's interesting. That's interesting.
So, Your Honor, currently, because the state intended to play this cat at 911 call, there's not, we are not calling other witnesses to discuss this specific day.
Which is the day after.
March 12th, correct, Your Honor. So currently, in terms of the state's witness list and what the state intended to introduce, this 911 and CAD.
This is the way y'all are introducing that the shooting occurred at Waters Road on March 12th?
There's two different shootings.
And there's two different shootings, Your Honor, but in terms of her
When's
car
the
window
other
being
shooting?
shot out, March 16th.
Okay, so let's not worry about that one. March 12th. This is the only way that y'all are establishing a shooting at Waters Road on March 12th, yes or no?
Yes, Your Honor. The state can call other witnesses or evidence about that shooting, but we intended to call and introduce this CAD report 911 currently.
I understand that y'all want to. Was that the only evidence that y'all were going to put up that this occurred on March 12th? Was this 911 call and boyfriend or husband and the discovery that on March 13th, this window was shot out? That's how y'all are going to establish a shooting on March 12th?
In order to cut down witnesses, Your Honor, we have other witnesses. We could call Ms. Zachary, we could call the responding officer, but in order to shorten, we get the complaint that we need to shorten the case. And so what we're trying to do is there's a 911 call. There's two 911 calls. There's a 911 call from March 12th.
Okay, are you planning to introduce that?
Yes, that's the day before.
Okay, but after the shooting occurs, correct?
The 911 calls as the shooting occurs, the woman is in her house and she's like, they're shooting down my street.
Okay,
Yeah.
so why isn't that enough?
Because this was the further evidence of that. So that's why we're playing the two 911 calls, because the March 12th call, right, there shows that she called, the first caller never went outside. All she says is there's shots fired. On March 13th, when that witness goes outside, she sees that her car has been riddled by bullets. Now, there's additional evidence that Ms. Zachary would bring in that her daughter heard the gunshots the night before, but we're not bringing that in. So what we're trying to do is tie in the first call from March 12th and then the call from March 13th. There's more evidence, but we're trying to, as best, get in what is relevant to establish that there was a shooting. Again, all of these shootings are in response to what happens in February with Wyatt and Lucci getting stabbed.
Is it riddled with bullets?
When you say, excuse me, maybe I shouldn't say riddled with bullets, but there are bullet holes in her vehicle.
How many?
I believe there's one to her vehicle, Your
Okay.
Honor.
Y'all can.
They went from riddled with bullets to her car had bullet holes, and now there's one bullet hole. Oh,
No,
Your Honor.
just no. We have got to figure out some things that we can do without in this case, and this is one of them. And not because it's hearsay or confrontation clause. Just because it's just too much. Waste of time. Okay, let's move on to the next.
Your
one.
Honor.
and she references back to Miss Love's motion. Oh, the judge did not like her motion to have the defense not objecting through 403. She did not like that at all. Oh, Miss Love, you effed up. You effed up with that motion, that ridiculously poorly written motion. Oh, you screwed up.
Yes.
May I just ask for clarification? Does that also apply to Frederick? I believe it's Frederick Whetstone, the boyfriend that lives there?
Yes, he
Okay.
doesn't need to testify either.
Okay, thank you.
If we have established the shooting occurred, we don't need more people establishing that the next day they discovered that the shooting occurred. All right, let's move on to the next.
Your Honor, may I have
Yes.
some clarification? Just the court is excluding the 911 call. What is it that the court is excluding?
Yes, that 911 call from whomever the next day that she discovered that there was a bullet to her car.
Okay.
And whoever that is, the boyfriend or the husband who was going to come and say, yeah, there was a bullet to the car.
Okay, he wasn't only going to testify to that. And I
What
know
else
that
was he going to testify to?
this is a person, she and he, who have been living next to this particular location for some months at least.
Okay.
They see who comes and go, and they see what cars, what vehicles come up to the location.
Okay.
They see the nature of the interaction
Okay.
of people with the location. And as far as that particular night goes, as Ms. Hilton said, she heard what she thought was gunfire. And we are, of course, adhering to the court's ruling regarding the 911 call, but she heard what she thought was gunfire. She saw evidence of it. They saw evidence of it the next morning. But
Okay, but
That's
he's
it.
not going to testify that the girlfriend heard gunfire.
no,
Okay.
he's not to test. No, no. Mm-mm.
So whomever this person is, the boyfriend or husband is going to come say, here are the comings and goings that I noticed over the course of the last few months, including the night of this shooting. Here's who I saw, or here's what cars or whatever.
Right.
Okay, that's
This
fine.
is what, right. This is what,
Yeah, I here's the thing. I don't believe Miss Love. I think she's lying to the judge again. She tries to get this person in so he can testify about the shooting. I don't believe her at all. She is buffering too much regarding this. And maybe that guy can testify. Hey, there were a lot of people moving around. I saw a lot of cars. I think they were gang members. I don't think that's admissible. Yeah, and now they changed it to she heard gunfire to she thought she heard gunfire. This is so stupid.
We anticipate from that particular witness, the the young woman that Ms. Hilton mentioned earlier, she, in addition to showing us, or in addition to having that bullet hole in her car, she has met with us and shown us the bullet holes in her house. We don't have those photographs. I'm just telling the court what.
Was she going to testify also?
We took her name off the list.
Okay. All right.
In an effort for brevity's sake, but I'm just letting the court know that these people who live next door to that location had more to talk about than just a bullet.
Okay, well, I mean, that's fine.
Well, Your Honor, in response to that, and I'm going off memory, the recorded statement that is really the only record we have of what Mr. Whetstone would be adding. I believe
What's the name of this guy?
I believe I'm being accurate with Mr. Whetstone, but
Wesley?
Whetstone.
Whetstone, okay.
And the issue I have is, and just to be clear, Mr. Whetstone, as I understand it, is not testifying, oh, I saw a Audi with this tag number. I know, I'm just using Shannon as an example. I know Shannon and I see him going in there.
Mhm.
The interview he gave to the police, it was much more like, man, there's all sorts of stuff going on at that house and it's ruining our neighborhood type generalized speak. I don't think that's appropriate. I don't think it's appropriate to just paint in a broad brush with testimony. And so I disagree with the state when they assert that this gentleman would be adding a lot more about what's going on with the house. It was just kind of a complaint that we all have with different people in our neighborhoods complaining about the residents of a certain house in the neighborhood.
All right.
Your Honor, it's not that broad, and we did provide contact information. It's not that general as it was placed before the court. We've provided contact information for anyone to speak to this person. So it's more detailed than what he provided.
Okay, so is it going to be something that tends to establish that the comings and goings were by a particular gang or group of people?
A particular group of people, and again, the nature, the type of traffic, if you will.
Meaning?
The house.
Meaning what?
He will not be saying, oh, there's drug dealing going on at the house, but just the frequency of different visitors to the house, the vehicles he observed at the house.
And the vehicles are going to be tied to
what YSL members, one in Well, one in particular belongs to Mr. Williams, for instance. For instance, I'll leave it there.
Okay. Well, if he is going to be able to testify to seeing particular vehicles with, whatever frequency he's going to testify to, and there's something that ties those vehicles to these defendants or other YSL members, then that seems irrelevant. So.
Thank you, Your Honor. And yes, it was the Waters Road. Obviously, the court has heard us say before is a YSL spot
Right.
and the shootings and the activity at the house.
Right.
What we're,
Okay. All right. All right, so the next thing that we need to look at is in item 4B, I guess.
All right, so they got that witness in, and I'm highly suspicious of that. That all of a sudden the argument changed into, oh, he's going to testify about other things. I think that was made up on the spot. And as you heard Mr. Sharp say, all they have from him about documentation about him is the bullet hole and that he lived there. They have no idea. They have no idea because this hasn't been presented to them. So I think she made that up on the spot. But since she's asserting this to the judge, I don't think the judge had much choice. So it will be interesting when that occurs, how obvious it will be that Ms. Love lied to the court again.
Okay, and the objection is,
Okay, next item.
what?
That guy will not know, I assume, but he will testify. Oh,
Anybody want to argue this one?
I suspect that Ms. Love will ask the people, am I correct in using these people who showed up was wearing red? Am I correct in you knowing this? She will do so much leading in order to get information out of him that he probably has no idea about.
I do, I'm just trying to find. I lost my spot.
Okay. So it's a picture of Mr. Sumlin, and then there's a post chasing that money, but my past chasing me. And I guess the objection to that is, and that's the purpose for which this is introduced, is for that, the language of the post.
that's part of it,
Well, what's the other part?
It's number 126 on our indictment.
Overt act number 126.
And Judge, I'll just, while the court is looking at the indictment, where he is displaying prominently that center tattoo on his person of YSL, obviously, along with all the others, and making that post. The fact of the posing on social media with the gang name in the middle and slime for life on his arm, and asserting publicly chasing that money, but his past chasing him. we would argue reflects at least part of what we are alleging that the gang has done or does in furtherance of the enterprise itself, obtaining money and property through a pattern of racketeering activity, him chasing that money, but his past chasing me, we would argue suggests that he has done things that were not legal. And this is an argument, this is one obviously that could be made at the end. The jury could infer from what they are seeing many things, but particularly we posted or we named this as an overt act, number 126.
Okay, and that was posing for the photo that he put on his account, displaying gang tattoos,
Mhm.
not the post, not the language. What you put in the indictment is
The description of it, yeah, the description of what happened. He
did
posed.
post for a photo released on someone's Instagram account displaying gang tattoos with YSL on his chest and Slime for Life on his right arm, an overt act in furtherance of the conspiracy.
Right,
Okay.
and the language, the language further shows how he is furthering the conspiracy.
How
by
is
saying,
that furthering the conspiracy?
chasing that money, but his past chasing him suggests that he not only does things or has done things that perhaps in chasing that money, they're not legal. He is continuing to chase that money in ways that are not legal.
What suggests that he is doing anything illegal by chasing that money?
Your
Isn't
Honor,
that what pretty much all of us who aren't independently wealthy have to do every day of our lives?
Your Honor, I'm not saying that it is with certainty that this is what he is saying. What I'm saying is that it is evidence that tends to, or that has a tendency to make a portion of our assertions or our allegations in the indictment true to the extent that it is relevant that he made or said that, made that statement on that posting. He is representing YSL. He is,
I mean, obviously, you know, it's all over his body, but how is the post, the language representing YSL?
the language, it's as if he said, I stay ready, or
It really doesn't seem to say that.
I didn't say
You
he-
can put that post in the picture without the language. Okay, what's next? File 5.
She lost again. Lost again.
Okay, this is another post. And this is also an overt act alleged. Is that right?
It is. It is.
Okay. Pose for a photo with the caption, suit up, it's wartime. Okay. All right. And what's the objection? What's the objection, y'all?
Your Honor, speaking on behalf of Ms. Stillwell, our objection is any of these comments on the right that
Past the suit up and lace up your boots one? The ones below that or including?
including.
Okay, well, given that that is what they allege to be an overt act in furtherance of the conspiracy, I think that one is going to come in. Does the state need the comments below that?
Mr. Stillwell, the OG bull with Shannon Stillwell and one Obama.
Okay. Okay. Who is that?
Antonio Sumlin.
Okay.
Is who?
Antonio Sumlin.
Is who?
One Obama is,
Right. So, and maybe I'm missing the bigger picture here. Who is Slime Bing Bing?
Your Honor, a person who is an associate of Shannon Stillwell and Antonio Sumlin, whose statement that suit up and lace up your boots this wartime was adopted and commented on favorably by Mr. Stillwell and Mr. Sumlin. Mr. Stillwell in posting, and Mr. Stillwell is reflected and tagged in it, and is posting the green heart emoji and the green snake emoji in response to it,
That's not accurate. That's not accurate. There's someone that we don't know who it is, and that's why I was confused, Your Honor, when you asked about after it's lace up your boots, it's wartime. Someone we don't know who it is. We're suggesting that he's an associate. I don't know how we're making those assumptions or suggestions if we don't even know who he is. And then we have who's said to be my client doing a green heart and a whatever that is. I think it's
I don't know what that is.
whatever it is. It's some sort of amphibious creature, it appears. Anyways, that's a reaction to the photo. I don't know where the state's asserting that this is some sort of adoption of someone else's comment. My client's in a photo, and he's not replying to the comment. You can reply to a comment if you want on these social media posts. He's just replying to a photo that he's tagged in. So I don't know under what theory of law, respectfully, with the confrontation clause in place and hearsay rules in place, that we would just allow Slime Bing Bing his out of court statements just in.
Your Honor,
and the fact that the state alleges it in the indictment does not move me in the least. I mean, we had no part in drafting this indictment, obviously, but just because the state alleges something in an indictment doesn't suspend the rules of evidence.
This would be the evidence by which they would establish that.
Well, I understand that, but it's still the rules of evidence, and I know you know this, Your Honor, but the rules of evidence still apply, even if they've asserted that.
For the record, Your Honor, the image on Slime Bing Bing appears to be a female.
They can't hear you. Well, I mean, the picture is,
Yeah.
Who knows whether,
Right. Who knows anything about?
I mean, honestly, y'all, if this were, it looks like these people are cleaning up a playground. I'd be like, yeah, if I were the defense, yeah, let's talk about this. Look at these bad guys. But hey, that's what.
Yeah. This is the state's case. So I have no idea how the rules of evidence allows this kind of garbage in. Just because it's a RICO case. I know that's the legislator's wishes, but I don't understand how the flaming fork can this be even remotely I mean, you have the Bill of Rights, you have the Constitution, you have does RICO just eradicate everything about due process, the rule of law? Everything? Seriously? But I understand that the judge, her hands are tied because of the legislators and some statutes. I understand, but this shouldn't be. Yeah,
But the state wants in for whatever reason. That's, I don't know how I don't know how anybody would find this to be an act in furtherance of gang activity, but
Yeah.
Well, that's why
they could argue that, I guess.
that's why I'm concerned with this. I agree with you. I don't necessarily have a problem with the picture. It's the caption by Slime Bing Bing that casts this in a different light. And I don't believe, well, first of all, we don't know his government name, and I have no reason to believe that that person is testifying.
You and me.
I don't think they know who it is either.
Your Honor,
Yes.
there's a extremely popular song by artist Lil Wayne, Grew, Grew, up, a screw up, and specifically it states, suit up and lace your boots up. It's wartime. So, this happens a lot in our case, but a lot of people just cite lyrics. And for that reason also, I mean, yes, we can cross on it, but it's just the same pattern. It doesn't show we are now going to war. So we would ask for it to be excluded.
Your Honor, with respect to, I think that the court had it exactly right.
Sadly, I have to give this to the prosecution because this is the rules under RICO. The judge can exclude due to cumulative, waste of time and everything. But if this is a separate piece of evidence in which the prosecution alleges is in the furtherance of the conspiracy, the judge can't do much about it. Oh, Steve Keat starts off with 5 gifted memberships, the first gifted memberships of today. And it was given to Mermaid Mary RN, Angel Australia, Corey Robinson, Lone Star Living, and Brandy M. Congratulations, folks. You are now a part of the Viking crew. You have access to all the members-only perks, which includes access to my Discord, access to members-only emojis, and foremost, access to members-only content on my channel, which includes the occasional members-only stream. Hey, so thank you so much. Thank you, Steve Keat, for your support of my channel. Thank you.
Accept the court's comment on the significance of it, but this is something that we've alleged. This is the evidence of what we've alleged. And we'd ask to be able to show the evidence that the state believes proves its case.
Okay, well, I'm going to permit it, and then y'all can all have a fun time arguing it, because
Yeah, they are going to have a field
Let's
day
move on to
on
the-
cross-examination showing this is just lyrics. Everybody quotes lyrics because it sounds fun. It's, yeah, whatever it is. But it is such a waste of time.
next one. So this is in folder 6, item B, I guess. screen grab of the first few seconds of the video?
Yes, Your Honor. So, there's a video that the state and defense, he agreed. It's a video that's played on a loop 3 times. We're only gonna play the first time that, the video was played. However, early in the video, Mr. Williams is seen throwing up the YSL sign, but it's very quick. And
Okay.
so 73-E55, just a screen grab of that initial portion, similar to what we've done with the surveillance videos that we entered. We might have the video, but we capture a screenshot of a particular portion for each one.
That's not a bad idea. I hope the defense thinks of this, that they should have a deposition with him. Sit him down for a deposition. That would be interesting. I hope they do, because he is a few weeks away, according to the prosecution.
And it's not shown, I mean, it's shown in the first thing, right?
Yes, but it's very quick.
So if I watch what's in the one before that,
And we can share it on our website, or if you just want to play it on your own.
and what's the objection?
Your Honor, there are so many videos that have come into evidence and are coming into evidence of Mr. Williams holding his hands.
Cumulative
Yes. And then it's cumulative on
of the
top of
video.
cumulative. Yes.
Yes, sustained. You can
This is
see
the
it
one where he
just as
says murder
easily.
gang bitch. This is different.
This is different. He says murder gang bitch, and he's also with Obama, another associate. We don't have, well, let me say this.
Okay, so the screen grab is excluded as cumulative.
But we didn't introduce the first 15
Yes.
seconds.
The judge is having a slaughterfest with the state's case. Slaughterfest at the moment for cumulative. It doesn't really curate
Here, but I think
the
the state
amount of
agreed because it's on a loop.
the states has put in so much garbage that I don't know. But I do agree they have to save time. And cumulative, I trust Mr. Steele's judgment. Let's just check in on the poll. Who wears the yellow jacket best? Either me or Miss Love. And I am at 89%. So I will end that poll so I can get out of this. Yeah. Oh. So you can see this again. I went to Atlanta and love didn't catch me.
So it just plays
The
it's a very
first
short.
is what it says.
So it's just
yeah.
one time is what I.
Right.
Okay, thank you.
All right, so then we can move down, I believe, all the way to folder 15. Who's autopsy?
Your Honor, I spoke with Mr. Steele earlier. We just need to confirm with Dr. Sim Stanley regarding the autopsy photos. And making sure that we selected the ones that she will need in order to explain Mr. Drink's injury. So we can just I hope to meet with her the end of this week so that we can select those photos, Your Honor.
Okay, so that's fine. The autopsy report, what's our issue with that?
Your Honor, we,
Sorry, we can't hear you, Ms. Hilton.
Sorry.
I'm sorry.
Yeah, my general practice with the ME is to introduce her report at the conclusion as a part of the record. It does not go back to the jury.
Okay.
However, I believe defense counsel will object to that.
Just don't, I never understood introducing something just for the record. I mean, if the witness needs to refresh her memory, I have no problem with that, but I object to it going into the record unless there's a reason. I definitely object the jury ever seeing it or being published, but that was my objection. I don't see any reason to say we're going to admit an autopsy report, but then we'll pretend like it never was in the record. It shouldn't be in the record in the first place.
Okay. I mean, it wouldn't go back with the jury, and I sort of hear both sides, so just tender it at the time. 16, folder 16. So whose firearm is this? Why is this coming in?
Found. This is one of the firearms found at Waters Road
Okay.
on the 16th.
But aren't they already have that in?
And just to add a little bit more contextual details, in one of the, or actually more than one of the wiretap calls, I think the court's already heard, where they're referencing the weapons at Waters
Yeah.
Road. And
Okay, and this is just found laying on this table at the time they come in there?
it's one of the weapons that's in there.
That's fine, I'll admit that. All right, folder 18.
Your Honor, we can withdraw. It's just a 2 search warrants.
Okay,
So that's fine. We won't.
Couldn't hear you, so.
they're withdrawing.
We're not going to make the search warrant.
Thank you.
Okay, then folder 21 would be our next one.
Same thing, Your Honor.
Okay, great.
Okay, the prosecution is starting to get it now that you need to withdraw. What's going on with my beard today? I need to comb it. That they have nothing to gain by arguing each and everything. So they are actually withdrawing, which is positive. Saves time.
Okay, then folder 23 looks like our next one. And I need to look at 5168.
Reminder, folks, you don't get midstream ads here. And all I'm asking in return is to head to that thumbs up and press it. So I will get a few likes on this. Because according to YouTube, the more interactions, like an active chat, active in the thumbs up and subscriptions and stuff, the more they promote my channel. So that is all I ask in return, and that you hit that thumbs up. Thank you.
So who wants to argue about 5168?
Yeah. I think this case will change dramatically during the defense case in chief. Well, of course it will, because it's not being handled by morons and incompetent prosecutors. But most favorable, I believe, will be Mr. Williams with Mr. Steele and Mr. Adams, telling the jury, Mr. Williams is not a leader. He's the musician. He tried to get people out of poverty. He gave people jobs to get them out of it. And then maybe present a witness or two to can attest to how people stopped doing crime thanks to him, because they got a job. And then have, what's his face now again? YSL Mondo, who openly says he founded the YSL gang, not the music label. And get him to testify about how Miss Willis may or may not have kept him out of this indictment, because she was his lawyer once upon a time. And my theory is still to this day that without her being his lawyer, getting all that information needed to defend him, they wouldn't have this case. She's using attorney-client privileged information to hand this to go to trial on this. That is my theory, and I'm sticking to it. Hey.
Nobody wants to argue about 5168.
Could someone just, we've reviewed all these, but I'm just trying to have in front of me what I'm talking about, and I'm trying to find it in this Dropbox.
Okay, well, you see there, like, each of the folders is numbered, so it's in number 23, and if once you open it, it's 5168.
Your Honor, we can withdraw.
All right. All right, folder 26.
Judge,
Yes, Your Honor, for folder 26, that's Mr. Ryan, I think that's Act 180, right?
I mean,
And you're not able to, okay,
go ahead.
you're not able, if you watch the video, you're not actually able to see who's actually posting it. It's alleged to be on my client's page, but you can't actually see him. And you see somebody else playing, or I guess watching the TV, and you don't know who's actually speaking either.
Okay. We're not gonna, there doesn't seem to be audio, right?
No, there's audio, Your Honor.
Okay.
And so you have Mr. Ryan, it appears, because he posted it on his page.
Allegedly.
Allegedly while in prison. And the video is of, we believe, Mr. Ryan watching Mr. Eppinger get a bond on TV. So they're in prison, similar, he has his cell phone in prison, and he's watching Mr. Eppinger get a bond, and he says, free, he's a number of different things, but he talks about slat, free, this YSL, we getting bonds on this shit, some other language.
So is there audio where somebody is saying that?
Yes, Your Honor. And we can play it. Your
All right, because when I just hit play, there's no audio, but that may be because of my settings on my computer. So, yeah.
Mr. Atkins is pulling it up, Your Honor.
It's because I had my volume turned all the way down.
Sometimes that happens.
So let me, actually, it may just be easier than joining the Zoom if I just hit play again now that the volume is up. Nope.
We're almost there. So that much time it pulls up.
It's on here.
Here's some.
Let's start that over.
Are you nervous? Your Honor.
Yeah, man, free my nigga Big Rich, man. Yeah, man, live chain gang. Fuck that boy. Fuck that boy. Strike that baby. Yeah, man. Free my nigga Big Rich, man. Fuck the DA. Yeah, we catching the bun on this shit. Yeah, and we about to catch that bun, fuck nigga. We coming to get you. You know what it is. Yes, sir. That shit in the hood right here, gang. Free the gang. Yeah, YSL shit. That's the hood right there, son. Yeah. Slack Benny.
For the love of all that's holy, stop recording yourself doing this
Slack,
shit.
man. Free the gang. That happened again for a blind, though, so it ain't for a blind, okay. Fuck Rashawn the Devil Boy. Yeah, man, free my nigga Big Rich, man. By the way, the gang way. Big Rich with the big head, man. Okay. They gave my nigga a bun today, man. Smell me. Why is it? They gave my nigga a bun today, y'all. Shit crazy.
Oh. Oh, that split-second song will probably get my stream demonetized. Crap.
And what's the argument for this exclusion, that you don't know who posted it?
We don't know who posted it, don't know who the speaker is, don't know who the second speaker is either.
Okay, and what's the state's response?
Your Honor, the circumstantial evidence in this particular case will allow the jury to infer that it was Mr. Williams' client. And at the very least, these are co-conspirator statements furthering the gang, furthering support of the gang, and publicizing their support of the gang, announcing support of the gang.
And who's this going to come in through?
This would come in through the investigator who saw this post and captured this post.
All right.
On Mr. Ryan's
I'm going to admit that over objection.
It's also going to be a foundation issue, and it'll cause for speculation.
What do you mean?
Because we don't know who's
speculation?
speaking. We don't know who's speaking. We don't know who has access to the phone or to his account.
That'll be things that you can cross-examine on. Okay, 28.
Okay, that's in.
I don't know how to get out of this one.
And for you who don't know, this is a commentary channel. This means I will pause on occasions and comment and try to explain what's going on and offer you my opinion. So I'm currently 20 minutes behind the actual live stream from court. We will catch up because they will have a break. Then they will go to lunch and stuff like that. But this is primarily a commentary channel, just so you know.
Which one am I looking at?
You're going to look at the one that says, I believe you highlighted MMS.
Okay. That's like red and green?
Yes, Your Honor.
Okay. And what is this?
Oh, I'm sorry. I'm sorry, Your Honor. So, Your Honor, this is the Verizon text messages that were entered a few weeks ago, Your Honor. Investigator Viverito, when she was reviewing the information, in order to make it easier for her to know who was talking, she just did color highlights.
Okay.
We will do some form of this, but as a demonstrative, Your Honor, because if you just read the Excel spreadsheet, it's difficult. So what she did in order to assist her is color code different speakers. And Your Honor, generally, the content in this text message is the conspiracy to stab Mr. Rayshawn Bennett. This is where that act begins, when they are planning it via the text messages. And the individuals involved are Mr. Khalif Adams, Demikion Garlington, Jaden Myrick through his girlfriend at the time, Ashley Ellison. And so we will introduce some forms to make it easier for the jury to see. Maybe not this exact document, but there will be some demonstrative to make these text messages easier to put before the jury and digest before the jury.
What's the objection?
I get that, Your Honor. My concern is that in this, what I'll call it a demonstrative, whatever the state's working on, there is irrelevant information that's placed out of context. For instance, my recollection, the first on that colored Excel spreadsheet, the first line says something, has a phone number, and it says SB. Now, I don't know if SB is supposed to be, we don't know who sent it, first of all. I don't know if SB is supposed to be a reference to my client.
We
I
don't
don't know.
intend to introduce that, Your Honor, because we don't know if it is, we cannot confirm that that is.
Okay,
Mr.
why don't
Stillwater.
y'all get in whatever form you're gonna want to use, get it in that form and then give that to the defense.
Yes, Your Honor.
And just to articulate it, my concern is the state's saying that there was a conspiracy, they're alleging a conspiracy, and they just named a bunch of people. My concern is simply, I just don't want references to my client just thrown in the midst of a demonstrative that apparently, allegedly involves a conspiracy involving other people.
Okay, well, get that in a form. Can y'all do that by the end of the day, Friday?
Yes.
Okay. Okay.
So that one is getting punted forward because the prosecution will put it in some kind of folder, give it to the defense, and then they can litigate it again.
That takes. All right, I think that takes care of the joint motion to exclude evidence as supplemented.
Okay, and a majority of that evidence was thrown out as cumulative. That's positive. What's next? Skipping ahead a bit.
I had a okay, I had a note that the state.
And I just got raided! Legal Vices and their viewers just joined. Oh, I'm going to send him an invite. Hello from Legal Vices, Jeff's crew. Jeff, I sent you a link. Now, this Jeff really doesn't need any much context of but he can give us his input as an attorney. Now, we are watching, for you who just joined, we are watching motions hearing in the YSL trial. And the judge just excluded a whole lot of evidence the prosecution wanted in. Now, some got in, most of it out because of cumulative and because this trial has been going on since November 28. And this judge is not having it anymore. She's telling the prosecution, trim it down, and then give me an actual number of how long you have left of your case in chief. Because it's still, we are on November 9th. This trial started, we are on October 9th. This trial started November 28th. We're almost a full year in, and we are still at the prosecution's case in chief. So now she is actively forcing the prosecution to trim it down. So this is motions hearings about evidence the prosecution wants in, which most of it is not let in. Welcome, folks.
On some co-conspirator issue with an unknown
Co-conspirator.
declarant called Unk, y'all were gonna figure out either excise that person's statements or come up with some kind of a limiting instruction. Has that been done?
The limiting instruction, no, Your Honor, what we looked at was excising. But
Okay.
we will give to counsel for the defendants a proposed limiting instruction and present it to the court. We have not come up with a limiting instruction. We believe that it provides context and that the court can instruct the jury that.
Ladies and gentlemen, it's Jeff.
Hey, how you doing?
I'm doing surprisingly good. Surprisingly good. I'm going to raise your microphone here because you're a bit silent.
Well, I can talk louder. Don't worry about that.
Yeah, I know you can. I know you can.
I actually finished my 2-hour stream in exactly almost to the second 2 hours. So I got a little bit of time. I can hang out and bump around with you because ordinarily my 2-hour streams go about 3 or 3.5. But how is day 543,596 of the YSL trial going?
We are at day 141. It is a motions hearing day where the prosecution, where the judge has forced the prosecution to trim down the excess fat. And
what, so soon?
Yeah, this judge, she is so sick of the prosecution. She really had it. She really had it this time. And so they went through 26 folders which they have done so far this morning of evidence, and I think she excluded 20 of them as cumulative and waste of time. So she's
can they just discard the whole trial as a waste of time? Are we to that point yet?
We should have been. We really should have been, but she seems adamant at bringing this to the jury.
Well, as I am a guest on your fine stream, and by the way, anybody that followed me over here that has not subscribed to Nick, what are you doing? Hit the subscribe button.
Yeah.
As a guest on it's been a minute too. As a guest on your stream, do you mind if I smoke a cigar whilst watching?
Jeff, you are breaking up.
I am?
Jeff. Hoo-hoo.
I'm breaking up?
You don't have or is it me?
I don't know.
Is it me that's breaking up?
I sound normal to me, and you sound normal to me.
I'm not. He is fine. Then it's on my end. What's going on here? I have.
I cause problems wherever I go.
Yeah, and it's not my connection. I'm looking here. I have 350 megabits per second down and 400. All right. Yes.
Well, I will bump out and come back.
It said, no, it's my connection that is unstable. For some screwed up reason, my connection is unstable. How can it be unstable? I have 400 up and down. Megabits per whatever that is.
Well, I'll bump out and come back in. See if that helps.
Maybe. And he's gone. Oh. But yeah, it seems to be a temporary glitch of some sort, because now it seems to be back to normal again. Okay.
Hi.
Hi.
Are we good again?
Yeah, it seems to be. It seems to just be a small glitch.
Well, I was just saying, as a guest on your channel, do you mind if I smoke a cigar while watching this with you?
Absolutely not.
Good,
absolutely not. I'm actually kind of envious because I don't smoke indoors, and I have plans of getting me one of these, where workers change builders and stuff, one of these trailers, and make it into a studio. But I have postponed it for a while because those are quite costly. But so I can get out of the house and have a cigar on stream.
Yes, that's
Mm.
the joys of being single.
Mm.
But there's also joys of
And
not
now,
being single.
what the actual app? It's on my end. I have connection unstable. Why?
I make everything worse.
No, I have had tons of people on. Yeah, and there is a storm brewing, but that shouldn't, because I have fiber broadband. So something's up. Well, before everything glitches up entirely, let's continue with the motions hearing and see what's going on now.
Only in as much as it gives context to the other statements.
Okay, so y'all have evaluated it and believe that it isn't going to make any sense to excise the other person's statements, so you want a limiting instruction, and you need to come up with that.
That is correct, yes.
Okay. Would this be a good time to talk about who all we still have coming up and how long they're going to take?
How many witnesses do we have left? 804?
I'm not sure, because they claim they took some away and now they have added on more. So I'm not entirely sure. But the judge has hinted that if they don't trim it down, she might even go as far as she puts a time limit on the remainder of their case in chief.
Do we know how many witnesses they actually had, roughly? Because they started out with, what, 750 something, and then they dropped it down
741, I believe, and then they were forced to trim it down to 400, and then they were forced to trim it down to 210, and which they claimed was absolutely crucial. And then they called two people from Hertz rental car company to testify for a combined 6 hours about Young Thug rented one car. So yeah.
Wow. All right. Okay.
But I do believe we are roughly at witness number 84 out of 220.
So 3 more years of the prosecution case. Got it.
Yeah. And this trial started November 28th. With Judge Glanville reading the charges, which took him 4 hours. Just reading the charges. And now it's October 9th. So we are not far off a full year in, and the state isn't even halfway through their case in chief. And this judge isn't having it anymore.
I think it would be. Let's talk about that.
From the defense,
Need a
we
bathroom
believe it
break.
would be a good time.
Let's do a bathroom break and let's come back and talk about that.
And since I've done a lot of commentary, we can skip ahead to after the bathroom break. I hope. That's a long ass. Hey, here they are.
Ray, freeze.
She looks happy.
Maybe in a few hours.
She looks grumpy.
It was on there. It just wasn't secure, so it didn't charge.
And I think this month's Temu box will arrive tomorrow.
Ooh. I should have one of these myself, one of those grifting streams, because the last few months with my panel show, people have been so generous I didn't even have to drink.
It's
Now-
been a tight month for a couple of months for people.
Now, I have said that if during one of those Friday streams we reach a certain amount of likes, yeah, that could turn into one. But we have had so much fun. But I need to schedule an ordinary grifting stream where people watch me drink stuff and eat weird stuff, and maybe I should have a Timo thing on that as well.
What I think we should do, this is totally something that doesn't have to be talked about in the middle of the YSL trial. You should send me some weird stuff to eat, and I should send you some weird stuff to eat.
I'm not entirely sure I am allowed to send our weird stuff to Korea.
Haven't you seen Godfather 2? Just put olive oil on the shipping label.
But I mean, you live in an apartment complex,
Yes.
or condos of sorts. Do I really want to send you surströmming?
No. Other weird stuff, please. But don't worry, I can.
You would be evicted in a heartbeat if you open that up on a balcony.
Well, this is Korea, my friend, where fermented rotten fish is on our menu here. So I can send you.
Not this one. Not this one.
Well, it's called hongo. It's essentially like a big skate fish, like a ray that they just leave it out to rot. Basically, it just turns into a big pile of ammonia, and it's from a special region. It's like from the west coast of Korea. It's a delicacy there, and that's where all of my ex-wife's family were from. And there was a wedding. There was a wedding with her and her cousin that we had to go to, and in the poshest convention center because they have lots of money. I'm from the poor side of my family, and my ex-wife was from the poor side of her family. But we went to the rich side of the family's wedding, and I remember going into the poshest convention center in this city of 5 million people I live in, and thinking, dang, they need to get their plumbing fixed. This whole thing just smells like a toilet. It just smells bad. And then I realized the closer we were getting to the wedding banquet hall, the stronger it got.
Oh.
Then they opened the doors and went, oh, hongo. They're serving hongo in here. But of course, the Koreans are going, yum. And I'm going, oh, God, how long do I have to stay in this room? So it could be comparable. But anyway.
Well, I mean, the chat is wanting me to turn your volume up. You're on StreamYard. You're at 200%. I can't do anymore.
And I'm as loud as you want me to be over here.
Apparently, you need to be a little bit louder for some odd reason.
Well, I can do this. This is way overmodulated for me.
Okay.
All right. Huh. Weird.
Yeah, that's strange. Because
All right.
usually I have to turn you down.
Yeah. So anyway, we can get you some silkworm larvae and some the hongo, lots of spicy weird shit. We can do it anyway.
How do you feel about salt crusted salt licorice?
Oh, see, that's really I had like a Norwegian friend that used to give me some, and then my Finnish pipe maker friend, Mikko, he sends me some occasionally. Those are one of those things you put in your mouth and you go, oh God, why am I eating this? Why is this in my mouth? And then about 20 minutes later, I think I'll have another one.
Yeah. They are surprisingly addictive.
You want more. Yeah. They're just awful, but you want more. Yeah. I actually do like them.
Yeah. Damn.
And they're great dissolved in vodka. That's what my Norwegian friend would do. He would dissolve a bunch of them in vodka, and it would mess you up real quick for some reason.
I wonder, we have one kind of alcohol that I wonder if I could get through customs.
No, don't try to do alcohol.
Oh.
Anyway.
Yep.
Sorry for that distraction.
No worries. let's continue with the trial.
Why is Snoop Dogg there?
All right.
Can you find the lawyers in this picture? Oh, court clerk's rocking a new hairdo since last
All
time I
right,
saw
so
her.
is the,
Oh, it's a new court clerk.
that would be
Since yeah.
next most pressing thing to go back to those wiretap conversations?
I believe that would be a good
Okay.
thing.
Yeah, and by the way, Jeff, this has been the state's case so far.
Yeah, I can tell. For everything I know from you and Kat about this trial, and it just seems any day I tune in, there's always some fuckery going on. So, which you can tell because literally the last two sentences the judge has started with.
Yeah. But the prosecution has been surprisingly submissive today. Surprisingly submissive. So something has clearly happened. Now, I want to read you the state's motion and just listen to it and give me your honest opinion about the writing and everything. Okay? Let me bring this up. Motion in limine to allow the state to present all relevant evidence to the jury and to deny defendant objections to the presentation of relevant evidence on the basis that said evidence is a waste of time.
I like it already.
Yeah. The state of Georgia, by and through Fannie T. Willis, District Attorney for the Atlanta Judicial Circuit, and the undersigned Chief Deputy District Attorney Adrian Love, hereby moves this honorable court to allow the state to present all relevant evidence to the jury and to deny objections to the presentation of relevant evidence on the basis that said evidence is a waste of time. Respectfully submitted. That's it. That's the entire motion.
Okay. Well, judging by the mountain of legal authority they have to support this motion, I would probably deny it.
It was denied.
Yes.
Yeah. It was
Not
denied.
surprising. Great success as I still have no clue what this trial is about. Yeah. Neither does the prosecution, apparently.
Now, they got a reply from Doug Weinstein, which is a glorious human being. Opposition to state's motion in limine to allow the state to present all relevant evidence to the jury and to deny defendant objections to the presentation of relevant evidence on that basis that said evidence is a waste of time. This is footnoted. Wow, that's really a mouthful.
That's good. I like that. That's good.
Oh, yeah. And the judge, she didn't deny the state's motion. She ruled in favor for the defense. So, yeah. So she really handed it to Ms. Love that, don't you ever do that again.
That's good.
Yeah.
Wow, that is really a mouthful. That's what she said. And literally she said, anyway.
Yep. I mean, the entirety of the state's motion was in the header.
Yeah.
And then they just repeated it in the
waste of time.
Oh, okay. Let's get back to this thing.
All right, I'll give everybody a minute to get their notes on the wiretaps, and we were kind of going through this chart that has the two different reference numbers.
And Your Honor, did you have received the updated, we shortened some, the
I
court
did
had asked
not.
us to
No.
reduce it. I will re-forward the email. It was sent probably about 3-4 weeks ago, but I'll resend it to
Okay.
everyone.
I mean, maybe I did, but I haven't printed it. Is it like one of these, but just shorter? Okay, that would be great.
Can't tell you substantially shorter, but it is short.
Okay.
Oh, Mr. Steele.
Do we still have to deal with the one that had sort of bogged us down and we stopped on?
Yes, Your Honor.
Now that I think about it, Your Honor, now that I think about it, the call that we ended on was the one that you had just referenced that kind of got us off track. So that call was PDF page 2184 on April 1st. So I'll pick up on the next call after that, which is
Well, we've got to make a decision on
Yes,
that
Your
one
Honor.
too, so. Jimmy, did they file a response?
Could you just say the call number as well? For
yes,
PDF 2184, what call?
the reference number 2158, Mr. Sharp.
Okay, thank you.
You're welcome.
When they are talking about the PDF file, they are not talking about the DD case.
Your Honor,
Yes.
Westmoreland over here. I wanted to make sure, is this?
Thank you.
No, it's okay.
A voice from somewhere.
Is this the call, Mr. Atkins? Is this the call that Attorney Harvey was arguing?
Yes.
Okay.
Yes.
And did you guys file a response? I know the last time you asked to file a response and we were waiting on it. I haven't received it, but maybe you filed it already?
No, we were going to just
So can we go?
oral argument on it. We did not file a written response to that.
Well, if you didn't, please, Judge, just pass it out.
So had we finished 2119? Reference 2119 from April 1st?
That's a
Yes
joke.
or no, I don't, I
One
just,
second, 2119 was,
I think maybe we did, I don't know.
I'm reviewing the notes, Judge.
Okay.
Your Honor, Your Honor, if it's reference number 2119, PDF page 2140.
What is that? Is that a page number or a reference number?
So the wiretap
Yeah,
used reference numbers. I also included PDF page numbers to quickly access.
okay,
So that's why there's both numbers, Your Honor.
okay, so it's reference number 2119, according to this. I only see one number on this chart.
On the far left? What chart did we give her?
The first two columns, the first column is the reference number and the second
I
column is
need
the
it on
page
the
number.
computer. I need it not to freak out because I'm going to freeze the top.
The mic's on.
Ms. Hilton, did you resend out the condensed version?
I'm sending it now.
Okay. Because I don't see
I sent
2184.
I sent it on September 21st at about 6:07 p.m.
But you're gonna resend it
Yep, I just.
for me.
There's so much garbage that never seem to, oh, we sent it, and then never arrived. And the judge sometimes says, well, that's the nature of internet. Well, maybe in 1997, not in 2024. If you actually send an email, it generally arrives.
Yeah, so and I don't know how it works in Sweden, but there's the niceties when you send emails to other lawyers. You go, for whatever reason, we appear not to have received your email of whatever date. Just means, oh shit, I forgot to answer.
Yeah.
Is this where the unk
Yeah.
conversation is? No.
No, Your Honor. You give me 1 second, Your Honor. I'll pull up my notes on.
Okay.
Nobody has any idea what they're doing in this case, do they?
The defense is doing their best, but they are often surprised by the prosecution who wants, oh, we sent you this, and this was in discovery on August 2022. We just had it under a different name, a number, and we didn't attribute it to the witness who is currently on the stand.
And this is like season 8 of Game of Thrones. Somebody left a coffee cup on the set.
Yeah.
But they didn't lose their coffee privileges yet. That's good.
No, they
So,
lost
Your Honor,
their snacks.
those two calls were, I have the PDF page number 635 and 820, Your Honor, which are March 17th and March 18th calls, was the two calls my notes had that referenced.
The UNC. Okay.
Yes, Your Honor.
All right, thanks.
I only have 10.
Yeah, one thing this judge has been really mad about is how the screwing hell
Okay,
did you not
so
handle
does
this
it
before the
show
trial
that
started?
we've finished
And,
on, and I don't,
and she did give Miss Love a real lashing out the other week, where she said,
Oh.
it seems like you're trying this case as it moves along. And that she hopes that this, I mean, yeah, but still no mistrial. Because that was regarding a piece of evidence they forgot to disclose to the defense again.
Great.
Yeah, there are 45 motions for mistrial in this trial,
And I'm surprised none of them have been granted.
None granted, but they should have, they could have, but they aren't. We are currently we're closing in on 300 sidebars. So the sidebars has been slowing down a bit since Glanville left. Yeah.
Well, maybe they'll pick up again. Who knows?
Yeah, maybe.
I don't know why, but I don't see a page number. But on reference 2119, did I make all the rulings that needed to be made? That's just the last thing I have anything written down for. I mean, I guess if we'd moved on to 2158, I had. And 2158 is the one that potentially has nested hearsay. Is that right?
Correct.
Okay.
Nested hearsay. I'm not entirely sure what that is. Because according to Georgia RICO, you can use third-hand hearsay.
2119, which is the call that had the nested hearsay, Your Honor.
Okay,
Yeah.
well then that's why I didn't have anything written.
Okay, nested hearsay, that call. Okay, I vaguely remember that the prosecution wanted in a jail call where multiple people talked about other people, which all should be hearsay. I mean, they couldn't identify most of them. Who was actually talking?
Well, that's a problem.
Yeah. That's a huge problem.
Down on 2158 then, because we stopped on 2119, I guess.
Yes, Your Honor.
All right. Okay. And the issue.
Good thing would be in a few
And the
minutes
issue
behind.
we've got is that nobody knows who Rel is, essentially, right?
Your Honor, I don't think that was the issue regarding rail.
Your Honor,
Yes.
I would humbly
Rail?
request Attorney Harvey argued this motion, and the last time that you heard in reference to this piece of evidence, and by the way, not knowing who Rel was an issue, but that the state asked to be able to respond to our brief. And so we've been waiting on that response. From my understanding,
and
they
now you know there isn't going to be one.
and now we know there isn't going to be one, but I would humbly ask if we could do this when he's here. I'm sorry, he's just ill.
Will he be back tomorrow?
I hope so.
Okay. All right. Well, we'll circle back on this tomorrow then.
Thank you,
On-
Your Honor.
On 2119.
Yeah, sadly, Mr. Harvey is a legend, and he's so good, so good.
Okay, so on to 2158 then.
Five new members. Cool.
Yeah. There has been a surge in membership and the last couple of weeks, and I'm
All right,
grateful for
everybody
it.
has now
Very,
the
very grateful.
updated wiretap.
I got 34 members yesterday,
And we're still on Garlington's.
which is an
so-
amazing number.
Okay.
Can we beat that today, chat? Just asking.
I see you're working on the pronunciation of chat.
Yeah. Year and a half later, it took. That was so annoying. It took people 6 months before anybody told me I mispronounced that word, because we Swedish, we don't have that sh sound. So for 6 months, I pronounced it chat, which makes it a bit different. I'm still working on it. But you assholes never told me. None in the chat told me. None
Yeah,
of
you shatty assholes.
Oh, so I'm still working on pronouncing it chat. Which also became a problem when I started covering this case with attorney Short.
Well, that's your pronunciation is actually better than the actual pronunciation. Shot sounds way better than shart. In fact, I would change my name if I was him.
Oh. Hey, thank you, D-Watch. Sub now. Yes, if you haven't subbed yet, please do. And give a thumbs up and everything. I don't have midstream ads, and all I ask in return is to give me the thumbs up and subscribe if you haven't. Now, I do have ads on the replay crew.
Mm-hmm.
That gives me an extra $3.
So what are there objections? And if so, what are they? And do I need to listen to it?
The dogs are snoring.
Somebody.
From the context, my understanding is this call. The problem with this wiretap is it involves Mr. Garlington, who's presumed innocent of everything. Apparently, it suggests that he's involved in criminal activity, drug dealing, different squabbles that he individually has. My understanding from this call is he's having some sort of problems with someone, but I just, that it seems to me that is a Mr. Garlington situation as opposed to a Mr. Stillwell or anyone else here situation. And I understand the allegation is they're part of a organization, but that doesn't mean everything you're involved in is part of that organization, even if that organization does exist. So I don't see the relevance of this call And, you know, of course, unless there's a hearsay exception, we're dealing with the words of Mr. Garlington, who is not going to be testifying.
Response.
Yeah, there's a lot of unindicted co-conspirators.
Yes, Your Honor. This call, Garlington, I don't know who he is speaking with. He mentions Copeland Woody calling him, and Garlington says they are discussing seeing someone and going to blitz their ass, which the state believes from talking to gang experts, when you blitz somebody, you're going to go shoot them, intending to kill them or at least shoot them and hurt them. And so when you're sending a blitz or you're going to blitz someone, you're going to do an aggravated assault with a deadly weapon. This specific call, it's a minute and 14 seconds. Given that the other male, who I do not know, is the one saying we're going to blitz their ass, the state would, if I could reserve on this specific call, because absent knowing who that male is on this specific call, it's Garlington talking with him about that, Your Honor.
Okay, so you're going to give that some further consideration.
Yes, Your Honor.
Okay.
In other words,
All
we
right,
have
so let's
no
move
idea who's
to-
talking or what to do.
The next one is reference 2532, page.
Yeah, the issue with that, blitz this, blitz that. Well, if that one didn't get blitzed, then what is it evidence of?
Certainly not
Page
RICO.
2559. Any objection on that one?
Yeah. They might have been talking about video games. And incidentally, they entered into evidence pictures of two people, one defendant and one non-defendant, if I remember correctly, who was playing Grand Theft Auto. And while doing that, they put out a photo on Instagram or whatever's, and they added on Grand Theft Auto lingo. And the prosecution entered that into evidence as gang activity.
Oh, great.
Yeah.
We ought to be ready on these.
We're ready. I'm just reviewing my notes.
Okay.
We're ready, but I'm not ready. There's a lot of video monitors in this courtroom.
Yep.
It's like a sports bar.
Yeah, they present evidence through that so everybody can see it, because it's a really, really large courtroom. Really, really large. And what was it, last week when Detective Gaither was back, the world's least competent investigator in Atlanta history.
First, my question for this, the proponent of this.
Yeah, she was not to have her face revealed, but on the Zoom camera is pointed at the witness stand.
Great.
But they also present evidence through those monitors. So the prosecution had evidence up there, and without warning the guy who handles the technology, they put that down, and behind was her face.
Oh, good. Great.
Yeah. Now, former Detective Gaither is quite a public figure, because she is the security officer for the Atlanta Hawks or Eagles or some sports team. So she's everywhere. Her face is plastered everywhere on the internet. So, yeah, it's so stupid. Detective Gaither is the cop who left after 19 years, a year before full pension. Then she took a job at the neighboring county's district attorney's office as an investigator and left after 3 months. Or as I call it, when one time, yeah, sure, maybe she was sick, really wanted to quit. But when you leave 2 jobs unexpectedly, and for you guys who don't know, I do labor law. She got the option, either quit or be fired. That's my opinion.
Yeah, could be.
Evidence is the relevance.
Your Honor, the state's happy to articulate relevance. I do think legally to exclude evidence, the state feels so. This specific call, what ends up happening is Miles Farley, who's charged with the murder of Shamel Drinks, he ends up going to Fulton County Jail. Before he goes to Fulton County Jail, they work on trying to get him protection, specifically to figure out where in the Fulton County Jail he is, because there's a gang war going on and people are getting murdered. And so what ends up happening in these next series of calls unpack this is they are working on, hey, when he gets to the Fulton County Jail, let us know where he is so we can protect him, keep eyes on him. And what ends up happening is 9 Deuce, YFN, the same rival street gang that the state has been discussing with the murder of Donovan Thomas and also Shamel Drinks, teams up with some younger Goodfellas. Goodfellas is a very prominent gang in both prison and jails in the state of Georgia. And what ends up happening is that there's a lot of the next series of calls, for the most part, are all going to discuss Miles getting locked up. Where is he going? And then he ends up getting jumped by rival gang members who allied with Goodfellas. And that creates a serious problem because Unfunk, who was a defendant in this case, and his defendant William's brother, YSL is a hybrid gang, as the state alleges, is a Goodfellas member. And so once this happens, there's a series of phone calls between Garlington, Unfunk, and high-ranking Goodfellas members in the Fulton County Jail of saying, people are telling me that YFN teamed up with Goodfellas. We didn't bless off on that. My apologies, Madam Court Reporter. So I want to give that backstory because there's like, you need to listen to these calls to unpack what I just proffered to the court.
Okay. All right, that seems pretty relevant. Any other objection?
No.
No, Your Honor, I mean, for the record, it's hearsay, but.
Okay, I think this would come in under the co-conspirator exception.
Okay, understood.
All right. So our next one
Hybrid gangs is whatever the prosecution says it is.
is 25.
Problem with this hybrid gang is that YSL, the music label, and people working for it and everything, you had both Bloods and Crips.
Oh.
And yeah, I don't think either the Bloods or the Crips would approve of joining in under the YSL umbrella. But I do believe that the defense has an actual gang expert who works at a national level who will testify to how stupid that is. But then again, so did Woody on the stand. Try to explain to the prosecution, no, YSL isn't a gang. You can't have Bloods and Crips in a gang together. They would kill each other.
Yeah,
but
that's problematic.
Yeah.
And also problematic is, dang it, I was just planning to change my name to Boom Funk, but apparently that's been taken.
I mean, I try to avoid disrespecting people, especially people who allegedly are gang members. But y'all need to get better street names.
No way, that's awesome. I want to be Boom Funk. That'd be cool.
I mean, Little D? Seriously?
That's
Woody? Yeah, sure. I mean, yeah.
34 and 2561. Unless are there new objections? I mean, if these are all kind of the same series of same substance.
And Your Honor, you're using the reference numbers?
I mean, I said them both.
Yes, Your Honor. Yes, Your Honor. So PDF page 2561 is referencing this same topic. It's Garlington discussing trying to get protection for Miles. And also 2656 is a three-way call with Copeland and Garlington discussing Shannon being in jail and Miles in jail and getting protection in jail.
Okay.
We have a POE
So yes, Your Honor.
gang
All right,
member.
so are there
Yeah.
other objections other than what was already voiced with regard to the one before? 'Cause my ruling would be the same.
No, Your Honor.
Okay. So then that takes us down, that would then cover how many of those, Mr. Atkins? When do we get to the end of that?
So, Your Honor, we should, embedded in this is PDF reference number 2779 and PDF page 2808 is in reference to Garlington and a gun. And so that.
Okay, 2779 is not on our new list, is it?
Hold on one second, Your Honor. I have,
Okay, I think this would have covered reference 2534, page 2561, as well as reference 2628, page 2656. Is that right?
that's correct, Your Honor. My apologies. I had two XLs
okay.
up and one was the old version. So, Your Honor, we should discuss.
We should discuss
So then
completing sentences.
The next one on the new sheet is 2833, page 2861,
That's another word I have a hard time pronouncing.
right?
Yes, Your Honor.
Okay, and is there objection to that?
Yes, Your Honor, we're going to object based off relevance and hearsay. And does the state know who the other party to this call is?
I don't think so, but.
Everybody's yawning.
Your
and
Honor,
speaking at half
2861.
speed.
It's the state's understanding that this is an incoming call from Frank Hubert, who's Goodfellas. He's a capo in Goodfellas. This is tethered. This individual's who these three-way calls.
Have you heard the
What?
not use thing? What?
No.
Woody explained that it's really, really nasty in Rice Street because in the showers there's still water and not use.
Oh yeah, that is a common rule of prison life. You never, ever, ever go barefoot into the showers.
Drip drop, water cold as a night clock. Slipping on the tile, ain't a friendly spot. Steamy like the sun up, but the vibe ain't hot. Sneakers sitting high, say a prayer on the dot. Voices echo out like a haunted house. Shivers down the spine, can't escape the mouse. Eyes shifting fast like a powder warehouse. Back against the wall, that's the jailhouse joust. Nut juice dripping, man, it's slipping on the ground. Ain't no innocence here, everybody's down. Bars might close in, but we're still battling the sound. Showers turn to prisons in the lost and the found.
Me and the AI songwriting app Suno is a dangerous combination.
Yeah.
I have a country version as well. Nah, we had enough of that.
Calls discussing protection in the jail primarily go through. That's who the state believes this is. This covers a number of items, so the state would like to play this call.
Okay, go ahead.
But what evidence do we have that he's Frank?
Oh, that was a hot mic. What evidence do we have?
We're
They are a year into trial and they're asking each other, what evidence do we actually have here?
Yes, he reformed convict knows. He knows.
Yeah, he knows.
2628 or 2833?
2833.
Okay.
Right?
Yes, Your Honor, that's
Okay.
correct.
Did we need to address something further on 2628 first? Okay.
Your Honor, my apologies for I have to re-log in. My internet went out without realizing it.
Okay.
Great.
Skipping ahead.
I'll be right back.
All right.
Yeah. Hey, we're going with you. Scarface. What's up, are you alright? Hey, we're going with you. Shit, what you in the room? Yeah, yeah, I'm in the room. You know, my door don't lock, though. I come out anytime. What you order? Hell nah, they just don't fuck with it. Yeah, but you got that shit. Yeah, that was. You had them right street fucked up, why? Oh, yeah. Shit, what you need? See, you know if I can do it, man. Come on, man. You know I fuck with it. He ain't so bad. No, I know that. Yeah, fuck it right. How many of them niggas? How many niggas? Of them niggas in your dorm? Man, ain't one nigga, man. One nigga that goddamn. One nigga waiting for it to touch his ass so he can tell on me. Yeah. Yeah. What? Hey, so where Quay at? Where Flo Quay on? Wait, Quay, who that? Huh? Who that? To my big no Quay? Nah, he on the K with AB. Oh, don't talk about with the big nose right here, little young nigga. Yeah. Yeah, on the west floor, he on Quay. Yeah, who on Quay on the sixth floor. They be calling. They had a phone too with the whole what you call the gate. Yeah, what Quay?
Are they speaking Swedish?
You talking about
No.
Oh, not English.
Oh, you say not JBL Quay? What Quay you talking about? He said the one got like JB LB. Yeah, Kel say he ain't know you. Hey, your little partner ain't never hit you back in the DM. What name, Miles? Miles. Did Miles ever hit me? Yeah, Miles ain't never DM just nobody back. Nah, you know I ain't DM his folk back. Oh yeah, see cause we still don't know what flow he on. He got to be still on clarification. That's why we're trying to see where he is. Yeah, he got to be on clarification. Yeah, what's up with Quay though? What you want to do to Quay? Nah, Quay good, he good. I was just asking that who how many of them niggas them done with Eddie? Man, now it ain't number shit ain't number one. Let me see, that shit ain't number one nigga in the whole unit. Yeah. Yeah, it ain't number one. Huh? I said, I really ain't got nobody. Shit, everything straight. I was just trying to make sure them niggas ain't straight, bro. Man, you know that shit. Get away. One thing about whatever side I'm on, but whoever I'm fucking with gonna be straight on team. Yeah. I ain't just got no goddamn one unit shit. They got a whole goddamn floor on both sides. Man, I got that way. But they know I ain't just popping my shit. Get away. I got the whole jail ready, bro. I ain't got to make one phone call. Yeah. Yeah. I got the whole man. Man, you don't know who your goddamn big brother is, bro. Come on, man. Man, I'm goddamn Cabo friend, boy. I know. I know what's going on. Right, well, I got the whole man. That way it ain't number three of us. They got damn couples in their jail, but we got the whole flow. Like, I'm talking about the whole Rice Street. Like, boy, we got this motherfucker on smash, bro.
That's why, listen, nigga needs, bro, my main man, you know my main man there, bro. I need that nigga back, bro.
I already know that way. But you,
bro, them niggas so pussy. Like,
that's why I get with.
Huh?
I say, I ain't me cut y'all get with. That's why I'm so ready to get out right get with. My guy so like, get with. But that's why I got down. That's why I just told real get with. I'm glad he just put me in a position I can be in, right? I can start my own family, you know what I'm saying? Like, I'm finna go crazy on these niggas on Scarface. Wait, I get saying, why they rape them like, oh yeah, I'm wrong with all this shit, man, for real, bro.
Hey, you know, like, yeah, for sure. Like, you know, the only nigga, but like, they let niggas come through the hood, walk through the hood, all type of shit, bro. Them niggas ain't, you know what a nigga be on for, bro.
I already know, but see, we already know something. We already know majority of them niggas some pussy, bro.
Like, them niggas probably on shit like, man, they don't want no part, like, nigga. Man, bro, you know how that shit is, bro.
I already know it. That's why I got there when I come home. I'm gonna fall back for a little minute, you know what I'm saying? But guess what? Boy, I'm gonna have my team walking through that motherfucker. Everybody who I fuck with, guess what? I can't do nothing but call and warn niggas, but get out the way, you know what I'm saying?
Yeah.
Nah, for real, like, yeah, why ain't I'm finna clean dirt? I'm finna clean. Guess what, man? Word gave me the green light, bro. I'm finna clean that shit up, bro.
Yeah.
Man, hell yeah. Man, I ain't tripping. All I got a nigga like him behind me. Man, shout out goddamn, man, I ain't bullshit. I'm telling clean that shit up, so, man.
Yeah.
That's for real, bro. Then you know, Ed, he got a nigga mad because niggas just seen him a couple months ago. Ain't no way in the hell you back right here with me, man.
Say what?
I say, Ed, he got me mad because ain't no way in the fuck you right back here with me, talking with me, you know what I'm saying? Like, but that shit felt good knowing I can call him, knowing he out there, you know what I mean?
You say what?
I said, Ed B, right?
Yeah.
I said, that shit got me fucked up because Charlotte no goddamn niggas want to see him out there knowing that I can call him. That shit was a good thing, you know what I'm saying? Like, that shit hurt me, Charlotte right back.
Cuddy said can't hang.
Oh, stewardess, I speak jive.
Oh, good.
He said that he's in great pain and he wants to know if you can help him.
All right. Would you tell him to just relax and I'll be back as soon as I can with some medicine?
Just hang loose, blood. She's gonna catch up on the rebound on the med side.
Just thought I'd provide a couple of translations for you. I sent another one just in case you were confused.
Thank you.
Niggas know, like, right here with me, bro. That shit, man, they can't be keep coming back to this bullshit.
Yeah.
Hell no. Where the hell you at?
Yeah, man.
Where the hell you at, Scarface?
I'm right here with my cousin.
Oh, okay. Yeah, hell yeah, man. Get away. You just gotta stay. Get away, bro. You gotta stay right. You gotta stay around them niggas from the video, bro, because you already know they ain't right.
I know it, bro. Listen, like, you know, something, yeah.
You gotta stay around them niggas, bro. The nigga ain't right, bro.
So far, I've understood the word number, shit, and the N-word.
I know who gonna pop some bubble, little bubble. I didn't have little bubble got down. Like, man, listen, bro.
What little bubble?
Little bubble. Yo, bubble.
What bubble?
Yeah, I'm skipping it.
How many elderly white women are on the jury?
None, I think.
Okay. How many people on the jury are actually going to understand anything we just heard?
I have no idea. But I think the composition is, if I remember correctly, 8 or 9 black people and the rest of different, non-blacks.
Okay.
If I remember correctly.
Man, little bubble. They know.
Oh, no, Georgia. And because
aware This is one of the longer wiretaps, so.
They are having audio issues in the courtroom, by the way.
They're being invaded by aliens.
Yep. It's $1 million courtroom and 50-cent audio.
Just waiting for the judge to take off her mask and start blasting people with her ray gun.
Give it another try.
All of our laptops are.
Okay, well, it doesn't seem to be echoing anymore.
I just want to make the court aware, Your Honor, in terms of the state is more than comfortable to keep playing this call because it is important to hear what is said.
Okay.
They discuss a variety of topics. I just wanted to make the court aware of the length of this. Usually the wiretaps are quite short,
Right.
a minute, 2 minutes. This is one of the longer lengths of the call.
Okay. So maybe I could hear what the objections are so that I know what I ought to be listening for.
Yes, Your Honor.
So, Your Honor, specifically on behalf of Mr. Stillwell, I object. We've already heard this part where this gentleman is saying he was disappointed with SB, who I believe he's referring to my client, Mr. Stillwell, because he was just locked up in jail with him, left, and then came right back. So that
and we just have to take his word for it.
The jail door is revolving for Mr. Stillwell is bad character evidence, and we're concerned about that coming in. In addition, Your Honor, we're just getting to a part involving what I believe to be someone named EI and G-Baby.
Oh.
And Third World is mentioned as well. And there's just a lot of, it's just gossip. I don't know the relevance of all of these characters and these people in this case, because to my recollection, none of these people have come up previously, and I'm not sure what the relevance is, what they have going on. They apparently have some animosity towards each other or some of the people, but it just seems to me that these are other people that Demekian knows, that he's talking to this person about what they have going on. And finally, Your Honor, to the extent that it is relevant, again, it just seems to be gossip, not in furtherance of any conspiracy or anything of that nature.
May I be heard, Your Honor?
And me too.
Okay. Judge, thank you. Carlton Matthews here on behalf of Mr. Mark Flavius Huey. We did hear in the beginning of the call,
Marcus Flavius Huey, wasn't he one of the Caesars of Rome?
This person kept mentioning the name Quay again, Quay. There's no indication on this call as to what Quay or which Quay they are referring to or who they're talking about. So I'm going to argue to the court respectfully that under a 403 analysis, that this part of that wiretap should be excluded or redacted out because there's no foundation to establish which Quay they're referring to.
All right.
Thank you.
And then Ms.
So many Quays to choose from.
Thank you, Your Honor. So our objections is relevance and it's hearsay because one is I don't think that the state, or I have not heard the state provide any evidence that this is Frank. I don't think that, and on our sheet it says other party, but I haven't heard anything to establish that this is Frank Hubert. Second is that there seems to be another party that is in the background. When the discussion between the two callers and reference to Quay, one of the callers seems to not know who Quay is, and he tries to guess around who's Quay. And then seeking clarity, someone else is in the background and says, you know, the Quay that was with such and such. we don't know who that person is in the background. So we're going to have a nested hearsay problem. Additionally, I think that it's not relevant. What you hear is a conversation of curiosity. Do you know where Quay is? What floor is Quay on? Is this something you want me to, do to Quay or tell Quay? No, Quay's good. Conversation in reference to Quay is over. So there's no furtherance of the conspiracy in reference to that portion of the conversation. So no furtherance of conspiracy, nested hearsay, and relevancy in reference to that portion.
She reminds me of somebody.
It's the state's
I can't think of who.
response.
The state would like to finish playing.
Yeah. Chat told me to tell you about Marquavius Huey.
Yes,
His mother and
fourth emperor of
sister
Rome.
was arrested for bribery of a jail officer.
Okay.
Who they bribed to move in contraband, which then allegedly Marquavius Huey sold to other inmates. They were arrested just a few days ago.
So I would suppose that they're going to add her name to one of the indicted co-conspirators.
I would assume that the state will try to. And yeah. And for me, it is unfathomable that he's a defendant.
Yeah, I'd be upset with my sister.
Yeah, but if he actually sold the contraband, how involved was he, and how much did he just fuck over the co-defendants?
Yeah, bit shouldn't have been caught, though.
Yeah. But they have video of the alleged handing over from the prison officer to Mr. Huey, escorting him to a secluded area where he allegedly sold. And they have testimony, and yeah.
That sounds bad.
Yeah, that sounds really bad. So the state will probably try to enter it as an intrinsic act.
Cool.
Yeah.
Never a dull moment in 141 days.
Oh, you sweet summer child. It has been so infuriatingly boring at times. I have to commend my viewers who have stuck to me this entire time to just say thank you, because I know I can barely do it. I don't know how you guys did it, but thank you for sticking around.
In the call and has.
That'll help. Okay.
Yes, Your Honor.
Okay.
But to be clear, I do believe he says I'm Capo Frank on the call, but that's one of the. I'm going to play the call.
Okay.
Okay.
Man, I'm telling you, listen, Shawty ain't, listen, boy, I'm trying to tell you, we ain't got to speak on Buddy too much, because he's not right. I'm telling you, boy. Oh, yeah, you know, that way he don't need to be stressing them all no more, because they supposed to be goddamn pushing up on him, you know what I'm saying? So, for goddamn giving you a heads up, don't get seen nowhere.
I think he talks for 10 seconds and the captions just say got.
When they get a chance to goddamn wipe it over, they gonna do it.
Okay.
Yeah, boy, nigga ain't fuck with, he don't need to be stressing. My uncle ain't told me that, so I can let goddamn bro know, shot ain't right, boy.
Oh, okay then, good. I know.
Yeah, see, he trying to play up on some niggas so he can keep somebody around him, you know what I'm saying? Like, yeah, bro, don't be, them folks trying to find the perfect time to goddamn wipe it over, bro.
Yeah, they're just like we had like, you know, everybody around me got, you know what I'm saying, got some real shit going on.
Yeah.
So, like, you know, I had all right, what about little G baby? Y'all don't fuck with bro?
Yeah, fuck with G baby, yeah.
Listen though, cause so y'all got shit going on with EI them?
Nah, all that shit straight, long they goddamn that way, all them niggas that was spreading that 3-level shit PLK, all them niggas, like the main ones, like the one that got a name, all them really been tapping in word, all them folks went up on the.
Okay, I'm bored.
And well, I have reached my jive tolerance for the day. It's time for me to go to sleep.
Okay.
I've reached my
Okay.
jive quota. Thanks for inviting, Nick.
Thank you for showing up and joining us, and thank you for the. By the way, how do you like my T-shirt?
Yeah, I like that. That's good. You finally got it. Huh? Yeah, I'm just wearing merch.
Yeah, I have ordered home my new merch, which is not a co-conspirator, which could be useful for people in Atlanta, because you might, at any point in time, you could be dragged into court and be an indicted co-conspirator.
Oh dear. Soldier on, my friend.
I will. Thank you so much again for showing up.
Have a great day. Bye, chat. Give him the likes and subs. He needs them because he deserves them.
Yeah, I do.
Bye.
All right. Bye-bye. Oh. All right. Let's see if they are still playing this. They are still playing this.
Nah, because goddamn G-Baby and EI got something going on. You know, G-Baby my man.
Jesus Christ.
On the phone, okay, he asked for my number.
Whatever stage decide, bro. Like y'all rock me, you know what I'm saying? So
how long is this damn call?
Y'all the one that I'm gonna call whenever I do touchdown, like y'all.
To address.
Oh.
On the set fly.
That's a 45-minute call. And they want to play all of it to the jury.
Let me know what's going on. Here, now.
So, Your Honor, just a couple things to address. On this call, when he's clarifying which Quay, because both Mr. Huey and Mr. Nichols go by that nickname. Some people call them Quay. And so he says not JBS Quay, Jonesboro South Quay, which is defendant Huey, the one that got locked up with SB, and defendant Nichols and Stillwell are both charged with the murder and locked up on the arrest warrants for the murder of Shamel Drinks. So he clarifies that. And also investigator Viverito, who is going to be introducing these wiretap calls, the ones that the court deems admissible, she will be explaining items like that. So the jury should not be confused about this specific who he is referring to.
All right.
In addition, Your Honor, yes, Your Honor.
I'll overrule that 403 objection. Go ahead.
And Your Honor, familiarity with what is going on in different criminal street gangs, some that you're allied with, some that you have a problem with or commit violence against one another with, is intricately important. And so Demekion Garlington speaking with Capo Frank, again, this is after this protection of Miles Farley, a YSL member and also charged with the murder of Shamel Drinks. So this conversation, they touch about a lot of topics and understanding who has a problem with who, has implications both in prison, jail, and outside in the free world. And so it is and what happens is Demekion Garlington, and Wiretap, they play calls, they minimize calls, but in these calls, there's a telephone game that goes around. So information that Demekion learns, he has conversations both before and after this where they share information, and it's important to know information about what's going on in terms of criminal street gangs or street gang members, because if someone has a problem with you and you don't know about it, you can get shot. Or if you go to a certain location and you don't realize, you need to be well aware of what's going on. It's important for the criminal street gang conspiracy itself. And so there's a number of topics that they address, specifically where people are in the Fulton County Jail, because again, if problems arise, they need to know where people are so that they can either have protection or know who else is around them. Also, Your Honor, there is discussions about, there's a moment where Demekion Garland, they're discussing G-Baby, who is very close with Kenneth Copeland, and EI, who is Eric Kendrick from Mechanicsville, used to be 30 Deep, and then I believe he rolled up or kind of transferred his gang allegiance to Goodfellas / PFK, Play for Keeps, which is a subset of Goodfellas. And so when they're discussing this, Demekion says, I told EI they had money on my head since 2015. And he says, and then the guys clarify, talking about EI, and he says, nah, Lucci. What he's referring to is Demekion Garlington. They had money on their head because of the murder of Donovan Thomas. So here you are in 2022, and Demekion Garlington is discussing, he references TIG records. These are the same TIG records that was discussed in the context of January 10th, 2015, that we currently are in terms of in the trial with jury. And so all of these is important for Demekion Garlington and YSL Street Gang to know about and learn, because Franco Cap has a lot of information in the Fulton County Jail. And there's multiple members when this call is made that are locked up in the Fulton County Jail. And so all of this information is important to know both inside the jail and outside. So it furthers the conspiracy and it keeps abreast of the conspiracy. And that's why the state believes that it is admissible and relevant. And the statements, it provides cohesiveness and reassurances because there's concerns if you're in the Fulton County Jail and someone's having violence begot to them and there's no protection. And so that is the state's response to the defense of objections.
Okay, I'm going to overrule the relevance objections. You didn't address the one objection about bad character. Do you have anything to say about that?
Your Honor. And specifically, was it Mr. Sharp referencing bad character of defendant Stillwell?
Right.
And from my notes of this call, the references to, I don't believe that they reference defendant Stillwell exacting violence on anyone. So and Mr. Sharp, I have a lot of notes on this, and so I'm trying to find the specific part.
It's towards the beginning.
Yes, Your Honor. It was right before we stopped it the first time, and it wasn't with reference to specific violence. It was this gentleman, and I keep calling him this gentleman because I don't believe that to be this gentleman Frank that the state believes it to be, which potentially I would think that kind of takes care of all their arguments if they don't even know who this person is. I don't know how they can determine what conspiracies are being furthered or anything else. But in addition to that, it was a reference that this gentleman was making. It seems to me that he's in jail. And he was saying, I was just with Shannon in jail. He was on my floor, and then he left, and now he's right back with me again. That suggests that my client is repeatedly committing crimes and ending up in jail. So
If that's all it says, I mean, that could just mean he moved to another floor and now he's back. So if I think more specific than that.
I think it says he got out and then came back, and he said, I'm disappointed, which would not be something that would typically be said by someone who switched dorms. But that's I have more general objections, but I guess I'll just wait. But specifically to that character objection, that's my argument.
Okay, well, if it's nothing more than that, then I'm going to overrule that. So what else?
Before that, thank you to Slidey Pie over at Rumble for your $2 Rumble rant, who says, thanks, Nick. We're in it for the long haul. Thank you so much for your support of this channel, Slidey Pie. Thank you so much. Let's continue.
Let me ask, is there any portion of this that is just chit chat that y'all don't need?
Your Honor, I have notes on the call, but my time hacks of, are not they're not in like 30 seconds. So I can take a close look and try to get as precise and exact on given the length of this call, Your Honor.
Okay, I think everybody would appreciate that.
Yes, Your Honor.
Oh, yeah.
Okay. I mean, there was some discussion about being able to spend money, if you were as rich as so-and-so. And I mean, unless there's something that is relevant to, goes to,
Your Honor, what I'll endeavor to do, and I don't ever like to write a check I can't cash, but given we have these days off, not days off, but days in court addressing motions, I would like to
never have a day off.
Yes, Your Honor, I would like to endeavor to provide this to everyone so that we can address it ideally tomorrow or Friday, so I'm going to try my hardest to get that redaction, Your Honor.
Great, thank you. All right, so why don't we break for lunch right now, and then we'll come back. And we don't have a jury that we need to feed today, or, give them time to eat. So it's 12:25 right now. Do we need a whole hour? Can we just take 45 minutes and try to get some more stuff done? 45 minutes, so 12:30. So why don't we be back and ready to go at 10 after 1. I think that's 45 minutes.
Okay. What I'm going to do, folks, is I'm going to do the rest of today's motions hearing, because there's so much I could have skipped over, and we are 3 hours and 42 minutes in. I believe if I do the rest as a recap at around 6 p.m., 5:30, 6 p.m., this would be much more tolerable. So that is what I'm going to do. I'm going to do this as the rest of today as a recap, and probably tomorrow as well, doing it as a recap. Thursday, that is. So I'm going to, let's see here, send you over to Catnot Williams, and you over at Rumble, you have to wait. Yeah, I can't send you over anywhere because Rumble doesn't have redirect yet. So yeah, thank you for this morning. It's been interesting, somewhat interesting, at least the first hour and a half before that damn call, on how much the judge actually excluded from the prosecution. That's really interesting. So, folks, thank you all for showing up. Thank you for gifted memberships, the Rumble rant. Thank you for allowing me to do this. Thank you for allowing me to try to translate this faster clock of a case and trial. And if you are in the Florida region, take care, because a landfall is imminent of Hurricane Milton. So take care. And I will see you all back here at around 5:30, 6 p.m. Eastern Standard Time. Okay. And folks, remember, hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. Okay? See you later. Bye-bye.